to Requiro. Today we are going to be talking about Luigi Mangione's case and the most recent updates on his case. And I do want to say a couple of things first before we jump into everything. So first things first, you guys probably noticed I'm in a new location instead of in front of my bookshelf. I am currently cat sitting for someone for a couple of weeks. You'll probably see me in a couple of different locations in the next couple of videos. And also I want to say sorry if it's very echoey. These people that I'm cat sitting for, they literally just moved in, so where I'm filming there's nothing in here, so it's very echoey in this room. And if you randomly hear a cat meowing, their cat loves to talk, so you might see her in the video. So yeah, I don't know the cat's name, so I just call her Baby. The owners never told me. So anyway, also I do want to say sorry if I sound a bit sniffly and my eyes are watery. It's because it is spring. I do suffer from bad hay fever and I'm mildly allergic to cats. So yeah, sorry about that. So the most recent update I do want to put here before we get into everything is Luigi Mangione did appear in court on the 16th of September 2025, literally yesterday. And when I'm recording this video, I will talk about this more in depth once we get into that part of the video. I go through things in order when I make these videos. So there's two really big important things I do want to bring up here that was brought up yesterday when Luigi Mangione was in court. So the first thing is the terrorist charges put against Luigi Mangione have been dropped, and all the evidence that they found on Luigi Mangione when he was illegally searched have been dropped as well, because that was unlawfully found. And we saw that at the beginning, we saw that in a couple of documents ago, we've seen that it was very much a thing. So very exciting stuff. So again, we will talk about that in a lot more detail, and we will probably see more of that later on as more documents come out. And you guys probably want to know this. Here is all the photos of Luigi Mangione when his court appearance happened. I'll put them up on screen for you guys. Hi, it's voiceover me. So I'm not going to put all the photos of Luigi Mangione when he showed up in court on the 16th of September 2025, just because we will be here forever and then this video will just turn into a slideshow of Luigi Mangione, and I want to talk about the case in the slideshow. But I will put all the photos of Luigi Mangione on the 16th of September 2025 on the website. If you want to go download them, they're going to be there. And I'm also only adding all the photos without the watermark, because there have been a lot of photos of Luigi Mangione, but those photos have watermarks on them, and screw those people. Photos of Luigi Mangione should be for everyone and not be copyrighted. So this is all the photos, or majority of the photos of Luigi Mangione without the watermark. So yeah, hope you guys like the little slideshow. And here are two videos of Luigi Mangione walking into the courtroom and then walking up the hallway into the courtroom. I don't know why they made them walk up and down the hallway with the photographers. Anyway, the first footage is literally from me when I screen recorded it literally last night when this was happening. You can probably see I have bags underneath my eyes. It was very late here when it happened, but I did watch it and I did screen record it because I felt like I needed to. Anyway, that was the video I also posted last night up on here with no context. We'll see if Fox News takes it down, because I literally just screen recorded it. We'll see if they take it down. And then the other video is literally him walking up the hallway again into the courtroom. So I'll put it up on screen for you guys.
How you feeling, Luigi?
Also, another thing I do want to add here is Luigi Mangione's legal fund URL has changed. You probably saw it in my little community tab, or if you follow me on other social medias, I posted up on there. But I do want to put it here to let you guys know, because a lot of you guys probably look at my community tabs. So if you didn't know, now you know. Luigi Mangione's legal fund URL has changed, so the old one does not work. So I'll put it in the description down below, and all these sources and everything I used in this week's video will be on the website on this week's episode. So if you guys want to go check it out, go ahead. And if there's anything I got wrong or anything like that, please let me know in the comments down below, and I'll sure to pin it or bring it up in my next video. Also, please be nice, don't call me crazy if you hate watching this. I don't appreciate that. Let's get into the video. So this is the most current information we have on Luigi Mangione's case as me filming this video, 17th of September 2025, literally the next day after Luigi Mangione appeared in court. I just realized there's a bunch of tiny rashes on me. There's one on my hand, there's one on my neck. There's a reason why I'm wearing my choker today with this. I'm trying to cover up my rash. I don't know what's biting me when I'm sleeping here. The 16th of August 2025. This is a document from the prosecutors, and it's basically them pondering if they want to bring Luigi Mangione to Pennsylvania. And do take this document with a little bit of skepticism, because I did get this from Reddit. So this is the document. I'll put it up on screen for you guys.
Service type the 14th of August 2025. Status date the 8th of December 2025. Service status Bernard, Jackie Atherton. Order taking under advisement the petition for writ of habeas corpus ad prosequendum. See Order Blair County District Attorney's Office. The 15th of August 2025. E-service served. Dickey, Thomas M. The 15th of August 2025. E-service served.
The 19th of August 2025. So a couple of documents did come out on this day. One from Luigi Mangione's attorney in Pennsylvania, and also another document from Karen Agnifilo, Luigi Mangione's lawyer in New York. Please take this document with a little bit of skepticism. I did get this from Reddit, and this person got this from Twitter. I don't care, it's called X now, it's still freaking Twitter, okay? Anyway, so do take this with a lot of skepticism. Basically, this is a document from Thomas Dickey of the habeas corpus he requested. We saw this in the last couple of videos where Thomas Dickey requested for habeas corpus to happen, basically, in Pennsylvania. I'll put it up on screen for you guys.
The 19th of August 2025. Commonwealth of Pennsylvania Commonwealth's Memorandum of Law regarding the process of obtaining a writ of habeas corpus. Blair County District Attorney's Office 0819202251. S-service served. Dickey, Thomas M. The 19th of August 2025. S-service served. In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, Defendant, filed on behalf of Commonwealth of Pennsylvania District Attorney's Office by Peter J. Weeks, Esquire, District Attorney PA, ID 201,051. Nicole M. Smith, Esquire, First Assistant District Attorney PA, ID 200,855. Office of the District Attorney, Blair County Courthouse, 423 Allegheny Street, Suite 421, Hollidaysburg, PA. Commonwealth's Memorandum of Law regarding the process of seeking a writ of habeas corpus ad prosequendum. And now comes the Commonwealth of Pennsylvania, BI, and through its attorneys, Blair County District Attorney Peter J. Weeks, Esquire, and First Assistant District Attorney Nicole M. Smith, Esquire, who averse as follows. Defendant, Luigi Nicholas Mangione. Defendant Mangione was charged at the above captioned criminal action numbers with forgery, utters forged writing, 18 PACSS 4101A3F3, firearms not to be carried without license, 18 PACS $6,106A1, tamper records or identification, writings, 18 PACS $4,104A, possess instrument of crime, 18 PACS $907, and various related criminal offences. On Ox about December 19, 2024, defendant Mangione elected to waive his preliminary hearing with a preservation of habeas and then voluntarily, and with the advice of counsel, waived extradition to the state of New York, where he faces homicide and related charges that would cause him to be removed from the jurisdiction of Blake County in order to first be prosecuted on his homicide cases. Subsequent to being placed into custody of the New York Police Department and Manhattan District Attorney's Office, defendant Mangione was transported to New York City, where he was taken into federal custody. Defendant Mangione was then charged with murder and related offenses in New York State Court and in federal court, and remains detained by the federal government. Accordingly, the undersigned then served a detainer by email and hand service to secure defendant Mangione's appearance after his homicide prosecution. Notably, the logistics and costs for the transportation and housing of defendant Mangione were significantly greater than a typical inmate due to the media and public attention generated by the New York allegations. Further, there were significant security concerns regarding the custody and transportation of defendant Mangione due to the public attention the case has received and the threats received by the criminal justice system regarding defendant Mangione's prosecution. Subsequent to defendant Mangione's custody being transferred from the Blake County Sheriff to the New York City Police Department, he was taken into custody by the United States government on a federal indictment for homicide and related charges. Consequently, defendant Mangione was detained in a federal prison where he remains. The undersigned have been in communication with Assistant United States Attorney Frank Balsamillo and the other United States attorneys prosecuting defendant Mangione, providing discovery to the United States government and to ascertain whether defendant Mangione would be physically available for court appearances in Blair County during the pendency of his federal prosecution. On or about February 12, 2025, the undersigned received a letter from the United States Attorney's Southern District of New York, which indicated that defendant Mangione would not be made physically available to Blair County until the disposition of his federal charges, including any sentencing proceedings. Also indicates that defendant Mangione will be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. The Commonwealth has had repeated follow-up conversations to date with the above United States prosecutors, and their position has remained consistent. Commonwealth received defendant Mangione's initial precept to schedule hearing and demand for personal appearance on or about June 20th, 2025, and immediately reached out to the federal prosecutor's office in New York. On or about June 20th, 2025, the undersigned received a letter from the United States Attorney's Southern District of New York, which indicated that defendant Mangione would not be physically available to Blair County until the disposition of his federal charges, including any sentencing proceedings. Also indicates that defendant Mangione will be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. The Commonwealth has asserted and continues to assert that the position of the United States Attorney's Office regarding the physical unavailability of defendant Mangione has made defendant Mangione unavailable pursuant to PAR, Crimp Commonwealth's detainer, and ongoing communication with the United States Attorney's Office in the Southern District of New York reflects its intent to secure defendant Mangione once he is physically available for prosecution in Blair County. Notwithstanding such efforts, counsel for defendant Mangione has ignored relevant legal authority and demanded, via memorandum submitted August 1st, 2025, that the Commonwealth secure defendant Mangione via writ of habeas corpus ad prosequendum, while the Commonwealth maintains its position that its ongoing efforts establish the requisite diligence for PAR, Crim 600, it prepared, filed, and submitted a writ of habeas corpus ad prosequendum to the court for signature. Inexplicably, counsel for defendant Mangione, who demanded the writ, then objected to presentation of the writ to the court for signature. The undersigned respectfully submits that Pennsylvania law provides for the Commonwealth to submit the writ and for a common pleas judge to grant the same. $6,503. Right to apply for writ general zoo, except as provided in subsection B. An application for habeas corpus to inquire into the cause of detention may be brought by or on behalf of any person restrained of his liberty within this Commonwealth under any pretense exception, where a person is restrained by virtue of sentence after conviction for criminal offense, The writ of habeas corpus shall not be available if a remedy may be had by post-conviction hearing proceedings authorized by law. 42 PACSAS 6503, $6,502. Power to issue writ. General rule: any judge of a court of record may issue the writ of habeas corpus to inquire into the cause of detention of any person or for any venue. The venue of matters brought under this chapter shall be as prescribed by General Rule 42 PACSAS 6502. Once the Commonwealth prepares the writ and a common pleas judge of a court of record, signs it, the Commonwealth forwards the same to the United States Attorney's Office, where the U.S. Attorney submits it to a federal judge and provides input as to whether the writ should be granted or denied. In the instant case, the Commonwealth is on notice and has provided the same to court and counsel that the currently pending writ of habeas corpus ad prosequendum will be denied. Therefore, it is respectfully submitted that this court has the authority pursuant to 42 PACS S 6502 to issue the writ, notwithstanding the fact that the U.S. Attorney's Office and federal courts may ultimately decide to deny the same. Respectfully submitted, Peter J. Weeks, Blair County District Attorney, Blair County District Attorney's Office, 423 Allegheny Street, St. 421 Hollidaysburg, Pennsylvania 16648. Respectfully submitted, Nicole M. Smith, First Assistant District Attorney, Blair County District Attorney's Office.
So that was the document from Thomas Dickey. So now we are going to be moving on to the document from Karen Agnifilo. I can hear the cat. He makes lots of noises. It's really weird. So now we are going to be moving on to a document from Karen Agnifilo. This is the response to basically the prosecutors getting Luigi Mangione's full medical records and violating HIPAA violations. This is the response to that. It will be very interesting to read, so I'll put it up on screen for you guys.
New York 10013. People versus Luigi Mangione, Bind. Number 75657/2024. Dear Judge Caro, we write in reply to the prosecution's August 8, 2025, response to counsel's July 17, 2025, letter regarding the prosecution's unlawful Aetna subpoena. While attempting to justify its inappropriate use of the prosecution's subpoena power, the District Attorney's Office purposefully ignores counsel's primary concern that at least one prosecutor improperly reviewed Mr. Mangione's protected medical records that the prosecution received from Aetna, as Assistant District Attorney Zachary Kaplan noted in his June 24, 2025, email to the court first addressing this issue. Upon first looking at the files and observing the number of pages, but before reviewing the files in their entirety, I realized that this appeared to contain a significant amount of materials. I stopped looking at the files and then obtained and reviewed the subpoena. ADA Kaplan, the 24th of June 2025 email. This email confirms that ADA Kaplan reviewed at least a portion of Mr. Mangione's protected medical records, but fails to disclose how many files he reviewed or what the reviewed files contained. This calculated lack of transparency is concerning, as the files that Aetna produced contained medical diagnoses and statements made by Mr. Mangione to health care providers to receive medical care and treatment. The District Attorney's Office has had multiple opportunities to explain the extent of ADA Kaplan's review of Mr. Mangione's protected medical records, including when someone from the District Attorney's Office spoke with the media after counsel's July 17, 2025, letter to the court, described in footnote 2 below, and in its formal August 8, 2025, response to counsel's July 17, 2025, letter. Nevertheless, despite these opportunities, the District Attorney's Office continues to refuse to acknowledge to the court or counsel the full extent of its improper review of Mr. Mangione's medical records. For this reason alone, this court should conduct an evidentiary hearing as requested in counsel's July 17, 2025, letter. Additionally, a gaping, factual chasm exists between the explanations provided by the District Attorney's Office and Aetna. The latter publicly insists that they behaved appropriately in responding to the subpoena, contradicting the District Attorney's assertion that the records were provided to them mistakenly in error. In fact, Aetna spokesperson Phil Blando made the following statements to CNN after counsel's July 17, 2025, letter, Aetna received a subpoena for certain medical records, and we provided them appropriately. The Honourable Gregory Carroll, August 19, 2025, the 7th of 18/S/Luigi Mangione medical records. Mr. Blando repeated this position after the prosecution's August 8, 2025, response, noting our response is the same as before, https://www.newsinisincida.com/no blames Aetna Defense Law Records Luigi Mangione Healthcare Records 2025-8. Given the factual discrepancies between the District Attorney's Office and Aetna, this court should conduct an evidentiary hearing so that the court can fashion an appropriate remedy commensurate with the gravity of the violation, as outlined in July 17, 2025, motion. Such remedies may take the form of discovery of all communications, oral and written, between Aetna and the District Attorney's Office. In addition, we request a full evidentiary hearing with sworn testimony by all people with knowledge of how the subpoena was drafted, how Aetna was directed to provide this information to the District Attorney instead of the court, while reviewed the protected materials, who was told about the protected materials and who supervised this process. Moreover, based on the evidence developed through this discovery process and the requested hearing, the defense reserves the right to seek various remedies, including the recusal of the prosecution team, suppression of evidence or dismissal of the indictment. Even more brazen, in its response, the District Attorney's Office defends making its subpoena returnable for a non-court day by arguing that CPL Section 610.25 states that nothing in this article shall be deemed to prohibit the designation of a return date for a subpoena duces tecum prior to trial. The 8th of May 2025 letter at 1, quoting CPL Section 610.25, 2. This statement purposefully misses the point and misstates the law. Although CPL Section 610.25, 2. allows a party to make a subpoena returnable prior to trial, the return date still needs to be an actual court date, not some random date that the District Attorney's Office chooses. After all, under New York law, a subpoena is a process of a court directing the person to whom it is addressed to attend and appear as a witness in a designated action or proceeding in such court, on a designated date and any recessed or adjourned date of the action or proceeding. CPL Section 610.10, 2. This language contemplates compelling a witness to testify in court, which can only occur on an actual court date. Moreover, this definition of subpoena applies equally to a subpoena duces tecum, CCPL $610.10. 3. As used in this article, subpoena includes a subpoena duces tecum. A subpoena duces tecum is a subpoena requiring the witness to bring with him and produce specified physical evidence. Consequently, a subpoena duces tecum must also be returnable on an actual court date. Here, the District Attorney's Office knew that there was no court appearance scheduled for May 23, 2025, yet they nonetheless issued a subpoena to command a witness to appear as a witness in a criminal action. As courts have noted, his subpoena power, whether exercised by the prosecution or defense, is not so broad as to allow attorneys to force witnesses to attend proceedings in which they are not scheduled to testify. People v. Neptune, 161 miscellaneous 2D 781 783, Sup. CT. Kings CTY 1994, see also People v. Cruz, 86 AD 3D 782, 783 3rd Dep 2011, c. BJ course of the possible consequences of a failure to comply with such subpoena. Courts have imposed limitations on the use thereof. Indeed, subpoenas can only be issued for the valid purpose of compelling the production of evidence before a court, and requiring a witness to attend one. As ADAC Dillon is well aware, the Manhattan District Attorney's Office for decades has explicitly trained all ADAs that a trial subpoena must only be returnable to an actual court date, as this is required by law, and any assertion to the contrary is disingenuous. The Honourable Gregory Carroll, August 19, 2025 criminal proceedings when there is no chance of testifying serves no valid purpose, quoting Neptune, other citation omitted, but that is exactly what the prosecution did here by subpoenaing Aetna as a witness for a non-court date. This was improper. Lastly, after acknowledging that mistakes do occur in court proceedings, the prosecution's response goes on to blame Aetna and defense counsel for the district attorney's mistakes. Specifically, the district attorney's office asserts that Aetna erroneously sent the district attorney's office materials that exceeded the request set out in the subpoena, and that, like Aetna, defense counsel owed and compounded Aetna's mistake by resending the subpoenaed Aetna files back to the prosecution in an email. The 8th of May 2025 letter at 2:3. This response by the prosecution is nonsensical. Even assuming Aetna's subpoena response exceeded what the district attorney's office requested, that still does not justify the prosecution reviewing Mr. Mangione's protected medical records that it was mistakenly given. Notably, the subpoena requested 2 items: I, Mr. Mangione's account number, and 2, the time period during which Mr. Mangione received coverage from Aetna. In response, Aetna produced more than 120 pages of Mr. Mangione's medical records. Yet, despite the vast discrepancy between what they asked for and what they received, the prosecution ignored the inconsistency and proceeded to start reviewing the protected medical records. In doing so, the district attorney's office knew it was reviewing information in excess of its subpoena. The blame for that lies with the prosecutors, not Aetna. Similarly, accusing defense counsel of compounding Aetna's mistake is baseless and misstates the facts. ADA Kaplan emailed the court and counsel of their egregious error on June 24, 2025, in an email that attached both their Aetna subpoena and Aetna's subpoena response containing Mr. Mangione's medical records. Counsel merely responded to this email chain, removing the court, to give the prosecutors an opportunity to explain why they violated the law by requiring Aetna to comply with their subpoena on May 23, 2025. As there was no court appearance scheduled for that date, a question the prosecution has still not answered. Counsel's response, which included the prosecution's original email and their attachments, did not attach anything new or anything the prosecution did not already have and review. The mistake was committed by the prosecution possessing and reviewing the records in the first place. By responding to the prosecution's email, the defense did not give something to the prosecution that they did not already possess and, more importantly, review. Once the prosecution reviewed Mr. Mangione's confidential and private medical information, they could not unring that bell merely by emailing them to the court and counsel. Once ADA Kaplan had already ingested Mr. Mangione's private health information, the damage had already been done. It is hard to see how a reply to their email after they had reviewed the records compounded Aetna's mistake, as the files were already in their possession and reviewed by them. By seeking to blame defense counsel for compounding Aetna's mistake, the district attorney's office is merely trimmed to distract from its own improper conduct of reviewing Mr. Mangione's medical records too. The district attorney's office attempted to do the same when speaking with the media after the defense filed its original July 17, 2025, letter addressing the prosecution's improper review of Mr. Mangione's medical records. https://abcnews.go.com/us/Luigi Mangione prosecutors violating health privacy rights defense story ID equals 123,863,209. That online article included the following: the error was compounded by defense counsel resending to prosecutors the very same. The Honorable Gregory Caro, August 19, 202s. For all the reasons stated above and in counsel's July 17, 2025, letter, we request an evidentiary hearing to uncover the full scope of prosecution's conduct and to determine how much of Mr. Mangione's medical records were improperly reviewed and by whom. Respectfully submitted.
So that was the document from Karen Agnifilo to the response for basically the prosecutors doing the massive fucking HIPAA violation. It's too soon in the video to be angry and swear right now, I'm sorry. So this bit's very interesting. Basically, Karen Agnifilo brings up in the document, basically, once the prosecutors got Luigi Mangione's full medical records from his insurance company, basically the person who received the document started reading the document, and then once they realize, oh, they have way more than they are meant to have for literally the two things they requested, Luigi Mangione's medical insurance company, and they actually mentioned how many pages they actually read before they actually realized they have way too many things than the actual two things they requested. And that is a massive HIPAA violation. Like, literally, they should have noticed that once how big the actual full file was. Like, what the fuck? Hi, it's voiceover me. So I want to explain myself a little bit more in that. When I mentioned they would have known how many documents they received when they opened the document. So I think in one of the documents, as the last document I talked about in my last video about the HIPAA violation, it was a PDF file, and if you click on a PDF file, it does say in a corner of how many pages that are in a document, and yeah, they would have known that if they opened the document of how many pages there are. Anyway, I just thought I should put that here. And another thing Karen Agnifilo brings up, basically the prosecutors fail to take accountability of their own actions, of them literally reading Luigi Mangione's medical records and taking accountability for that. And she also mentions in the document, after this has happened, the prosecutors went straight to the press to explain the situation. My last couple of videos with the massive HIPAA violation, but I am going to bring it up here as well. So the prosecutors do like leaking information about Luigi Mangione to the press, like we've seen before in the past, where they leaked Luigi Mangione's driver's license, number you get when you're born, I don't remember what they're called, and also where he used to live to the public, when that's like very personal information. And they literally went straight to the press once they realized, oh, we accidentally read Luigi Mangione's medical records. Oopsie, we need to say we didn't mean to do it, and they go straight to the press for that kind of stuff. And it's like, they still know that information. They can still go to the press and learn about Luigi Mangione's medical history and tell the press about it and say, oh, or like say it's a leak of Luigi Mangione's medical records to everyone to know about, when literally it's none of our fucking business. So I do find it interesting Karen Agnifilo did bring that up, because it very much could be a possibility and they could do that in the future. Honestly, looking at everything the prosecutors and police have done in this entire case, I don't doubt they would not do that, if that makes sense. And I mentioned this in my first video talking about Luigi Mangione's case. Basically, the media does not like him whatsoever. You guys probably noticed it. I noticed it 100% when this thing first started. Basically, the media does not like Luigi Mangione whatsoever, so they go with whatever that fits their agenda of them not liking him and proving what they think of him is right. So it makes sense for the prosecutors to go to the media after they get called out on their fucking bullshit and basically saying, oh, we didn't mean to do this, oopsie, please side with us, and directly going to the media about that, who 100% don't like him. So it makes sense for them to do that, but it is very angry and frustrating compared to the rest of us and me making these videos where trying to get the accurate information and trying to be not as biased, if that makes sense, as much as possible. And this thing with the prosecutors, it kind of reminds me at the start of the year when one of the prosecutors accidentally listened to Luigi Mangione's phone call to his legal team, and it was like they said, oopsie, it's an accident, we didn't mean to do this, and then continue listening to the phone call. It very much reminds me of that. Karen Agnifilo also brings up in the document, basically the prosecutors basically abuse their power, saying, oh, if you don't give us the court document on this date, you will go to jail for a full year. And in reality, there was no court date, it did not exist, it was very much an abuse of power, and it is like very disgusting for them to do that. I mentioned that in my last video, and I do apologize. I feel like I am gonna repeat myself a couple of times in this video from my last video. A lot of documents that were like in that video, some of those things are also brought up in the new documents for Luigi Mangione's case as well. Karen Friedman also brings up basically the prosecutors blamed Luigi Mangione's healthcare insurance, basically blaming them for basically them reading the documents. That makes no sense. Basically, they probably just panicked and just sent everything because, they didn't want to go to jail for a year, So they probably just panicked and sent everything because they probably thought, oh, okay, we'll send everything. So we don't get in trouble if we don't accidentally send something. Again, it is a mistake on them for sending the full document, but it was not their fault for them to read those documents, if that makes sense. Again, they're failing to take responsibility of their own actions. I know this is way too soon in a YouTube video to start yelling and swearing, I said that earlier, but I am gonna put this here, I don't care, but what the fuck? This has happened so many times. We've seen it in so many different documents in the past. From this case, from the prosecutors messing up, lying, abusing their power, or pretending they didn't fuck up when they did. What the fuck? I know it's way too soon to swear in this video, but who cares? I will bleep myself for this. And in reality, the prosecutors are basically trying to distract everyone, saying, no, we didn't read his full medical records or even a part of his medical records, when in reality they did. They're trying to distract everyone to hide what they fucked up in this entire case. It makes me so mad though. It's why are they doing this? If they had anything official, they wouldn't have to keep doing this, if that makes sense. Sorry for the random continuity, my phone died and I needed to charge it. And basically, the prosecutors were blaming Luigi Mangione's legal team, and they went straight to the press about it, saying, oh, look how mean they are to us. We didn't do anything wrong. They're so mean. In reality, no, they're the ones who fucked up. They're the ones who broke a fucking law multiple times and so many different occasions through this entire case. And then they go to the media saying, oh, we made a little mistake, oopsie. In reality, no, it's bigger than an oopsie. So it makes sense for them to go to the media and say, oh, look how mean they are to us. We didn't mess up. It's not our fault. In reality, it is. They need to take accountability to their actions. My eyes are teary, and I don't know if it's pollen, I'm emotional, or it's cat. I feel like it is two of those things. Or maybe all three. I don't fucking know. Karen Friedman requests for a evidential hearing, basically for everything they mentioned in the response, and also everything that was mentioned in the 17th of July 2025 letter that was also done. They request for that to happen, so I really hope that does happen in the future. We'll see what happens again in the next couple of months. I take back my last statement, I think it's just allergies. And I know I should save this until the end of the video, but I've been noticing this more and more. This case is becoming way bigger than just a person shooting another person, if that makes sense. This is turning into something way bigger. The 21st of August 2025, it is a document from Thomas Dickey, Luigi Mangione's Pennsylvania attorney, and this is basically a filing of the habeas corpus have been filed. So I'll put it up on screen for you guys. Hi, it's voiceover me. So I totally forgot to mention in this part of the video, I also got this document from Reddit, so take it with a little bit of skepticism. I say that with every single document I get off Reddit and not a reliable source. Anyway.
In the Court of Common Pleas of Blake County, Pennsylvania, Commonwealth of Pennsylvania, Luigi Nicholas Mangione, defendant, number 2024 CR 2724, Hon Jackie Atherton Bernard Pete Weeks, Esquire Nicole Smith, Esquire Thomas Dickey, Esquire, Presiding Judge District Attorney 933 First Assistant DISTRCAPRNEY Counsel for Def Sudent, Order and now, this 12th day of August, 2025, the court having received a petition for writ of habeas corpus ad prosequendum filed by the Commonwealth on August 8, 2025, following the telephone status conference wherein the court advised counsel that any request for issuance of a writ shall include the legal authority for the same, and, the Commonwealth having failed to do so in its petition, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that The court will take under advisement the Commonwealth's petition for writ of habeas corpus ad prosequendum. The Commonwealth shall file a memorandum citing the procedure and legal authority it is relying upon in filing the aforementioned petition to bring defendant to Pennsylvania for the purpose of litigating his pre-trial motions, following waiver for extradition. 3. The Commonwealth has 7 days from the date of this order to comply with this order by the court.
So we've seen this a couple of times in my last couple of videos talking about Luigi Mangione and the filings from Thomas Dickey, and basically in this document the prosecutors have 7 days to actually respond to this, so we'll see in the future if they respond or not. I haven't seen anything yet they have responded, so we'll wait and see. The 22nd of August 2025, this is a document saying Luigi Mangione unavailability to basically do a virtual appearance. Again, he does have the right to be there in person, and it's totally fine for him to keep rejecting to do them virtually. Again, we've seen this multiple times in the last couple of weeks for the prosecutors to keep requesting for him to do them virtually when he has the right to do them in person. Hi, voice over me. So this is another document I got from Reddit. I'm sorry, I totally forgot to bring it up when I was recording. I'm sorry, I'm like off my game in this video. Again, this was actually the next day after Luigi Mangione showed up in court. So I'll put the document up on screen for you guys.
The 21st of August 2025 Blake County District Attorney's Office. Notice of defendant's unavailability for personal service / pre-site for consent to remote appearance. Dickey, Thomas M. The 21st of August 2025 service served.
But yeah, Luigi Mangione does have the right to be there in person in Pennsylvania for all those court appearances. And I do apologize, I do feel like I am repeating myself a lot in a lot of these videos. A lot of things are kind of like similar over the last couple of weeks and months with Luigi Mangione's case. They are saying similar things, so it will be kind of normal for me to say similar things. If this makes sense, I don't know. I don't even know if these videos are good when I make them, but no one else is doing it, so. The 25th of August 2025, this is a document, this is another document from Karen Agnifilo. This is basically a document requesting more time to have a decision, to have the psychiatric evidence to be used in this case, so I'll put up on screen for you guys.
August 25th. 2025, the Honorable Gregory Caro Supreme Court of the State of New York, 100 Center Street, Part 32, New York, New York 10013. Re. People vs. Luigi Mangione, Bind. Number 75657/2024. Dear Judge Caro, as the court is aware, the defense has been directed to provide intention of offering evidence pursuant to Criminal Procedure Law Section 250.10 and FDAF on August 25th, 2025. We write to request additional time to determine whether he will be serving Fitch notice for reasons that we would be willing to provide to the court ex parte, because the people have yet to complete their full production of discovery and because no trial, or indeed even a pre-trial hearing, has been scheduled. There is no prejudice to the people from the delay requested here. In addition, Mr. Mangione's Fifth Amendment rights to due process and against self-incrimination, his Sixth Amendment right to call witnesses in his defense, his Eighth Amendment rights against the arbitrary application of the death penalty, see Chapman v. United States, 500 U.S. 453, 1991, require that he not be compelled to provide information pursuant to 250.10 at this time, given the pending death. Eligible indictment in the United States District Court for the Southern District of New York. The law is clear that the court must weigh the defendant's constitutional rights to a defense against prejudice to the people from late notice. People v. Sidbury, 42 NY, 3D 497, 508, 2024. People v. Burke, 88 NY, 2D 257, 1996. Even in a typical case, where there is no separate federal death penalty case, a trial court's discretion concerning the timing of 250.10 notice is constrained by a defendant's trial rights. Sidbury, 42 NY, 3D at 508, Burke, 88 NY, 2D at 266. in contrast to the massive prejudice to the defendant that comes with compromising his constitutional rights in this case and the federal death penalty case. The prejudice to the people is non-existent, as we have previously stated, and we reiterate now. The defense will consent to any adjournment the people require to meet any Section 250.10 evidence offered by the defendant. The Court of Appeals has observed that the governing principle of 250.10 is eliminating the element of surprise to the prosecution. Sidbury, 42 NY, 3D at 506. People v. Almina, 93 NY, 2D 571, 578, 1999. There will be no surprises here. The people can take whatever time they need. The Honourable Gregory Kerr, August 25th, 2025. We recognise and appreciate that the court has already granted the defence additional time to provide notice under 250.10. However, we ask the court to recognise the truly unprecedented situation facing Mr. Mangione and his counsel given the multiple prosecutions for the same offence, including one that involves the death sentence. Respectfully submitted, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan, counsel for Luigi Mangione.
Document, I was very much like, what the fuck? Why do they keep putting more things on Luigi Mangione closer to his court appearance in September? And when I was reading Reddit comments about this as well, a lot of people had the same reaction as I did. It's like, what the fuck? Why do they keep placing more things on Luigi Mangione? Luigi Mangione's next court appearance is slowly closing forward. You guys will probably notice that when we go through the documents further on in the video. I very much noticed that when I was gathering information for this video for you guys. I've noticed that they keep putting more and more things on Luigi Mangione. So it is very much that, like, why do they keep putting more things onto him when it's literally not necessary? Man, this outfit's cute, but I do not appreciate me pulling up every 5 seconds. Basically, Karen Agnifilo basically explains in the document, Luigi Mangione is basically dealing with the same prosecution, but like 3 times, and one is dealing with the death penalty. So having a extension to consider to use this as a option is very much needed because of everything Luigi Mangione is dealing with right now. I do really hope they get more time to have this decision to see if they want to use it or not. Also, if you guys don't know what psychiatric means, because I don't know, you just don't know what it means, it basically just means like mental health stuff. It's the 27th of August 2025. This is the prosecutor's response to Luigi Mangione's motion, so I'll put it up on screen for you guys.
United States District Court, Southern District of New York, X, United States of America, v. Luigi Nicholas Mangione, defendant. Government's memorandum of law in opposition to defendant's motion for an informational outline of certain aggravating factors. Sean S. Buckley, attorney for the United States, acting under authority conferred by 28 U.S.C. Section 515. Dominic A. Gentile, John Ziang, Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys of Counsel. Table of Contents. Preliminary Statement. Background argument. The law does not require the government to provide evidentiary detail of aggravating factors. 1. Applicable law discussion. The defendant has received sufficient notice of each aggravating factor. Grave risk of death to additional persons, substantial planning and premeditation, victim impact, future dangerousness. The cases cited by the defendant are distinguishable. Conclusion. Table of authorities. Cases. California versus Ramos, 463 U.S. 992, 998 99, 1983. Gray versus Netherlands, 518 U.S. 152, 166 70, 1996. Payne versus Tennessee, 501 U.S. 808, 825, 1991. United States versus Arnold, number 15 CR 20652, GCS, 2019 WL 5,842,925, at star 5, E.D. Mitch, November 7th, 2019. United States versus Battle, 173 F. 3D 1343, 1347, 11th to 1999, United States v. Bin Laden, 126 F sub 2D 290, SDNY 2001, United States v. Brasino, number 11 CR 77, PPS, 2014 WL 12,682,281, at star 23, NDI'd, November 14, 2014, United States vs. Candelario Santana, 368 F sub 3D 316, 325, D, Puerto Rico 2019, United States vs. Cuya, 2011 WL 5,878,382, MDPA, November 23, 2011, United States vs. Higgs, 353 F, 3D 281, 325, 4th to 2003, United States vs. Kinney, 462 F, 2D 1205, 1212, 3D to 1972, United States vs. Lecroy, 441 F, 3D 914, 930, 11th to 2006, United States vs. Lee, 274 F, 3D 485, 495, 8th to 2001, United States vs. Lira Plaza, 179 F sub 2D 464, 472, EDPA 2001, United States vs. Montgomery, 10 F sub 3D 801, 822 N, 7, 823, WD 10, 2014, United States vs. Nguyen, 928 F, sub 1525, 1550, D. Kansas 1996, United States vs. Aphometer, number 17 CR 201, LMA, 2019 WL 527,696, at star 12, ED La, February 11th, 2019, United States vs. Sablin, number 00 CR 531, 2006 WL 1,028,780 at star 2728, D. Colo, April 18th, 2006, 6 United States vs. Sapov, 17 CR 722, DKT, number 482, SDNY August 11th, 2022, United States vs. Solomon, 513 F sub 2D 520, 538-39, WDPA 2007, United States vs. Solomon, number 5 CR 385,513, 2007 WL 9,702,871, at star 2, WDPA, June 26th, 2007, United States vs. Taylor, 316 F sub 2D 730, 741, NDI in 2004, United States vs. Tipton, 90 F, 3D 861, 896, 4th to 1996, United States vs. Witten, 610 F, 3D 168, 187 88, 2D 2010, United States vs. Williams, 00 CR 1008, NRB, 2004 WL 2,980,027, at star 23, SDNY December 22nd, 2004, Statutes 18 U.S.C. Section 3592, C. 5, 18 U.S.C. Section 3592, C. 9, 18 U.S.C. Section 3593, L. 18 U.S.C. Section 3593, 2, 18 U.S.C. Section 3593, C. Table of Authorities 18 U.S.C. Section 924G, 18 U.S.C. 2261A, 1, 18 U.S.C. 2261A, 2, A, 18 U.S.C. 3591, 3598, 18 U.S.C. Section 924, C, 18 U.S.C. Section 2261, B. 118 U.S.C. Section 2261, B. 1, 3, Rules Fed, R. Evid 403. Other authorities: Dan Mangan, deny, defend, depose. United Healthcare CEO killing shell casings had words written on them. CNBC, December 5th, 2024. Tracking Luigism online. City Journal, August 14th, 2025. Wanted CEO posters and other threats emerge after Mangione arrest. NBC News, December 11th. Words on ammo in CEO shooting echo common phrase on insurer tactics. Delay, deny, defend. Associated Press, December 5th, 2024. Preliminary statement: the government respectfully submits this memorandum of law in opposition to defendant Luigi Nicholas Mangione's motion for an informational outline of the evidence the government intends to offer to prove various aggravating factors alleged in the government's notice of intent to seek the death penalty. The defendant, who makes this motion before a trial date has been set, claims that he lacks the detail necessary to adequately defend against the aggravating factors at a potential sentencing phase of a trial. The defendant's motion should be denied for two reasons. First, the law does not require the government to identify in an outline all of the evidence it will present to support the alleged aggravating factors at the penalty phase, let alone to do so well in advance of a trial that has yet to be scheduled. Second, the complaint, indictment, notice of intent to seek the death penalty, and pre-trial discovery, which extends beyond Rule 16 to include, for example, witness statements, provide sufficient notice of all the aggravating factors on which the government intends to rely. Accordingly, the court should deny the defendant's motion as premature. Background: on December 4th, 2024, at approximately 6:45 a.m., the defendant approached United Healthcare CEO Brian Thompson from behind on West 54th Street in Midtown Manhattan and fatally shot him several times using a 9mm handgun equipped with a silencer. The defendant had arrived in New York City more than a week earlier, traveling by bus from out of state. He was captured in Altoona, Pennsylvania several days after the murder. On December 18th, 2024, the defendant was charged in this district by complaint in 4 counts. 1. Stalking by means of interstate travel, in violation of 18 U.S.C. 2261A, 1, and 2261, B, 1, 2. Cyber stalking, in violation of 18 U.S.C. 2261A, 2, and 2261, B, 1, 3. Murder through use of a firearm, in violation of 18 U.S.C. Section 924, J, a death-eligible offense. 4. Possession and discharge of a firearm equipped with a silencer, in violation of 18 U.S.C. 924, C. On April 17, 2025, a grand jury sitting in this district returned indictment 25 CR 176, MMG, charging the defendant in the same 4 counts. On April 24, 2025, the government filed its notice of intent to seek the death penalty. The notice, setting forth the aggravating factors it intends to prove at sentencing. The notice identifies 2 statutory aggravating factors: grave risk of death to additional persons, 18 U.S.C. Section 3592, C. 5, and substantial planning and premeditation, 18 U.S.C. Section 3592, C. 9, as well as 3 non-statutory aggravating factors: victim impact, future dangerousness, and selection of site and victim for an act of violence, 18 U.S.C. Section 3593, 2. For purposes of this motion, the defendant does not challenge the non-statutory factor concerning the selection of site and victim for an act of violence. Argument 2. The law does not require the government to provide evidentiary detail of aggravating factors. The defendant seeks broad and detailed advance notice of the theories and facts the government may introduce during a potential penalty phase, claiming he is currently blind to such information. Def. Memmott 4, DKT, number 40. However, neither the Federal Death Penalty Act FDPA, 18 U.S.C. 3591, 3598, nor the Constitution imposes any such obligation on the government. The statute does not require the government to disclose the specific evidence it intends to present to prove the existence of aggravating factors, and courts have consistently rejected similar demands. Moreover, any request for further detail, if warranted at all, is more appropriately considered at a time closer to trial. The defendant's motion is, at a minimum, premature. Accordingly, the weight of authority, including decisions from multiple courts of numerous district courts, squarely foreclosed the defendant's position at this point in the proceedings. 1. Applicable law. The FDPA requires the government, a reasonable time before trial, to provide notice that it intends to seek the death penalty and believes the circumstances of the offence justify such a sentence. If the defendant is convicted 18 U.S.C. section 3593, 1. That notice must also set forth the aggravating factors the government intends to prove in support of a death sentence. 18 U.S.C. section 3593, 2. As numerous federal courts have held, however, neither the FDPA nor the Constitution requires the government to disclose in advance the specific evidence it will use to prove those factors. See, for example, Gray v. Netherland, 518 U.S. 152, pages 166 to 70, 1996. Affirming that there is no constitutional right to general discovery in criminal cases and indicating that due process does not require advance disclosure of the government's aggravating evidence in capital sentencing. United States v. Requiro, 441 F. 3D 914, 930, 11th to 2006, the government was not obligated to outline what specific pieces of evidence it planned to use to support the aggravating factors. United States v. Higgs, 353 F. 3D 281, 325, 4th to 2003. The FDPA and the Constitution require that the defendant receive adequate notice of the aggravating factor, not notice of the specific evidence that will be used to support it. United States v. Lee, 274 F. 3D 485, 495, 8th to 2001. Lee had no rights to advance notice of the specific evidence the government would use to prove those aggravating factors. United States v. Battle, 173 F. 3D 1343, 1347, 11th to 1999, the government is not required to provide specific evidence in its notice of intent. Thus, while a defendant is entitled to notice of the aggravating factors that may render him eligible for the death penalty, that requirement is satisfied in FDPA prosecutions by the indictment and the notice of intent to seek the death penalty, which together fulfill the government's constitutional and statutory obligations. 2. Discussion. The defendant contends that the notice is overgeneralized and lacks the factual specificity necessary to provide meaningful notice of the government's case in aggravation. Def. Mem. 3-4. In particular, the defendant argues, with regard to the statutory aggravating factor of grave risk of death to additional persons, that the notice fails to identify the individuals allegedly placed at grave risk of death and the conduct by the defendant that created that risk, i.d. As to the non-statutory aggravating factor of victim impact, the defendant claims that the notice does not provide the particular personal characteristics of the victim the government intends to prove, or the specific family members, friends, and company, workers affected and the nature of the impact on them, i.d. He further claims that, with regard to the non-statutory factor of future dangerousness, the notice provides no detail regarding when or how he allegedly expressed an intent to target an entire industry, how he purportedly intended to do so, or how any such conduct demonstrates future dangerousness, i.d. Relying on these purported deficiencies, the defendant asks the court to compel the government to provide an informational outline. In so arguing, the defendant points to the heightened due process standard that applies in death penalty cases, i.d. at 6. But, although the law affords heightened protections in capital matters, it does so through procedural mechanisms such as a bifurcated proceeding, instruction on the factors to be considered, and meaningful appellate review, rather than by prescribing the particular substantive factors that should be deemed relevant to the capital sentencing decision. California v. Ramos, 463 US 992, pages 998 to 99, 1983. Emphasis in original. The overwhelming majority of federal courts have concluded that the FDPA itself provides those procedural safeguards in federal capital prosecutions. For example, the FDPA imposes many procedural requirements on the government, including that the government provide advance notice of its intent to seek the death penalty and of the aggravating factors alleged to exist, and that it prove those factors beyond a reasonable doubt to a unanimous jury. But it does not require that the government provide a guide to its case or identify all of the evidence that it will offer at sentencing in support of the aggravating factors. To the contrary, the government satisfies its legal obligations about notice when it informs a defendant of the aggravating factors it intends to prove during the capital phase of a trial. As every federal court of appeals to have considered the issue is held, the notice is the only notice to which the defendant is entitled regarding aggravating factors. See, for example, Requiro, 441F, 3D at 929, Higgs, 353F, 3D at 325, Lee, 274F, 3D at 495, Battle, 173F, 3D at 1347. The overwhelming majority of district courts across the nation have followed the precedents set by the courts of appeals. See, for example, United States v. Arnold, number 15 CR 20652, GCS, 2019 WL 5842925 at Star 5, ED Mitch, November 7th, 2019. The FDPA and the Constitution give defendants the right to advance notice of the aggravating factors the government seeks to prove at sentencing, but do not require advance notice of the specific evidence the government will use to prove those factors. United States v. Afomita, number 17 CR 201, LMA, 2019 WL 527696, at Star 12, ED La, February 11th, 2019, denying request for informational outline of evidence because notice of intent met statutory and constitutional requirements. United States v. Bricino, number 11 CR 77, PPS, 2014 WL 12,682,281, at Star 23, ND November 14th, 2014, denying request for informational outline and holding that neither the Constitution nor the FDPA required the government to preview its evidentiary support for the aggravating factors it has disclosed. United States v. Solomon, 513 Fs up to D 520, 538-39, WDPA 2007, finding that ceding indictment and notice of intent suffice to advise defendant of allegations, and denying request for further detail. United States v. Sablin, number 00CR 531, 2006 WL 1,028,780 at Star 2728, D. Colo, April 18th, 2006, T. He notice of intent does not need to include specific details about the evidence to support denial of a defendant's motion to strike a statutory aggravator. United States v. Taylor, 316 Fs up to D 730, 741, NDR in 2004, the notice of intent informs the defendant that the government intends to seek the death penalty and lists the aggravating factors that the government will seek to prove. The statute requires no more. United States v. Nguyen, 928 F. Sup. 1525, 1550, D. Kansas 1996, holding that the government's notice of intent was permissible even though it list, ed. only the aggravating circumstances and provide, d. no detail about the evidence the government intend, ed. to offer in support. This court should follow the same course. The defendant further argues that the court should order the informational outline because it will enable the court to fulfill its gatekeeping function. Def. Mehmet 7, 12, 16. This argument is similarly unavailing. As in any criminal case, the trial court in a capital case serves a gatekeeping function as to the admissibility of evidence. In this, as in any other case, The defendant, after reviewing the government's pre-trial notice of its witnesses, and upon receipt of those materials at the appropriate time, the court can then properly exercise its authority to rule upon such motions and the concomitant law relating to such disclosures. Compare Fed. R. Evid 403 with 18 U.S.C. Section 3593. C. The court's ability to serve its gatekeeping role does not depend on the government producing and disclosing to the defense an outline detailing every piece of evidence it will rely upon at trial in advance, let alone before a trial date has even been set. Indeed, the Courts of Appeals decisions cited above make this point exceptionally clear. Although certain district courts have exercised their inherent authority to require evidentiary outlines with respect to particular aggravating factors, other courts have declined to do so where, as here, the defendant was afforded sufficient notice to prevent any risk of unfair surprise, and the victim is singular and the consequences of the murder readily identifiable. See, for example, United States v. Candelario Santana, 368 F sub 3D 316, 325, D, Puerto Rico 2019, denying request for informational outline because defendant failed to demonstrate any danger of surprise. United States v. Montgomery, 10 F sub 3D 801, 822 N, 7, 823, WD 10 2014, refusing to exercise inherent authority to order government to provide informational outline of aggravating factors. United States v. Kuya, 2011 WL 5,878,382, MDPA, November 23, 2011, courts have not, however, shown a willingness to order informational outlines each time a request for such outlines is made. Courts refuse to order such outlines where there is no danger of surprise at trial or a potential sentencing phase. The same is true here, as the defendant cannot credibly claim surprise given the extensive information already in his possession. See Part 3, Infra. This court should not accept the defendant's invitation to alter the balance struck by Congress and the FDPA or rewrite its procedures to ensure what the statute already provides: heightened procedural protection for the defendant. Due process and the law simply require what the notice already sets forth. Because the government has provided notice of its intent to seek the death penalty and the aggravating factors on which it intends to proceed, the court should deny the defendant's request for the disclosure of additional information. 3. The defendant has received sufficient notice of each aggravating factor. Denial of the defendant's motion as premature is particularly appropriate here given the extensive evidentiary detail regarding the government's aggravating factors already contained in the discovery produced to date, which totals more than 5 terabytes of data, some of which is summarized in the detailed criminal complaint filed in this case. To the extent defense counsel seeks further direction, the government is prepared to identify for them the specific discovery materials that support the aggravating factors, including by reference to the pertinent Bates numbers cited in this brief. See, for example, Solomon, 2007 WL 9,702,871, at Star 2. When considering a defendant's request for additional information concerning aggravating factors, a court should consider all information that has been disclosed to the defendant in the course of the prosecution, citing United States v. Kenny, 462 F, 2D 1205, 1212, 3DC 1972, the defendant's characterization of the government's notice as bare-bones, sketchy, or vague is baseless and contradicted by the record. Def. Mem. 1, 3, 7, 8, 14. Far from offering a mere list of aggravating factors, the government has provided substantial detail. The indictment and the complaint preceding the notice set forth a comprehensive narrative of the murder, including photographic evidence of the crime, the defendant's movements in the days and weeks leading up to it, the steps he undertook in planning the attack, his chosen weapon, and the extensive efforts he took to facilitate his escape. In addition, the murder was captured on video and broadcast widely in various national media outlets, further underscoring that the factual circumstances of the offense have been detailed with unusual depth. Taken together with the expansive discovery produced in this case, these materials make clear that the defendant has more than enough information to appreciate the likely evidence that would be presented at the penalty phase of this case. While the government has no legal obligation to do so, it has functionally already shared many of the theories and facts that would be pertinent to sentencing. Def. Mem. 9. The discovery the government has provided includes, among other things, video evidence capturing the murder itself, proof that the defendant stalked the victim and the surrounding neighborhood in the days and weeks before the murder, extensive writings authored by the defendant evidencing his preparation and motivation for the attack, witness statements and state testimony, medical and forensic reports, and dozens of hours of security camera footage. Thus, the defendant is already in possession of the evidentiary support for the government's aggravating factors, and there is no risk of surprise. In short, the government has given the defendant far more than the law requires, and, as demonstrated below, has provided adequate notice of each aggravating factor. 1. Grave risk of death to additional persons. The indictment charges that from on or about November 24, 2024 up to on or about December 4, 2024, the defendant traveled to New York City for the purpose of stalking and killing Brian Thompson. On December 4, 2024, at approximately 6:45 a.m., the defendant approached Thompson from behind on West 54th Street in Midtown Manhattan and shot him multiple times in the back as Thompson attempted to enter the hotel where his company was hosting a conference. The complaint, which was filed 4 months prior to the indictment, described the specific circumstances of the murder and included a still photo of the security camera video that captured the incident. Compl paragraph 6A. The photograph and the originating video show a female bystander standing only a few feet from Thompson as the defendant fired multiple shots. The government produced multiple hours of video of the defendant's actions before, during, and after the murder. USAO 000113118, USAO 0001132, USAO 000113338, USAO 0001155. In addition to capturing the female bystander, the videos also depict multiple other individuals in close proximity to the shooting who were likewise placed in harm's way. ID. That circumstance is hardly surprising, given that the defendant chose to kill his victim on a public street in Midtown Manhattan, directly adjacent to a major New York City hotel. During the early one, the evidence described herein is illustrative, not exhaustive, and is not intended to limit the scope of the evidence the government may seek to introduce at the sentencing phase of trial. Morning hours when people were commuting to work. By discharging multiple gunshots in that location at that time, the defendant created a substantial and unjustifiable risk to bystanders and passers-by. 2. Substantial planning and premeditation. To establish this factor, the government must show that the defendant participated in a considerable and significant amount of planning using the plain meaning of those terms, that is, more than the minimum amount sufficient to commit the offense. United States versus Tipton, 90F, 3D 861, 896, 4th C 1996. As set forth in the complaint and as evidence throughout the discovery, the defendant's conduct demonstrates substantial planning and premeditation. On November 24, 2024, 10 days before the murder, the defendant traveled by bus from another state to New York City and checked into a Manhattan hostel using a forged driver's license with a false name. Compl paragraph 7. This step alone reflects advanced preparation and an effort to conceal his identity in anticipation of the crime. In preparing for the crime, the defendant took the time to write the words deny, depose, and delay on the bullets he used, 2 of which were recovered at the scene of the murder as shell casings, because the bullets had been fired, and 1 of which was recovered as a live round. The act of inscribing words onto ammunition is not spontaneous. It demonstrates a level of planning that goes beyond a simple act of violence and reflects a heightened premeditation and calculation. When arrested, the defendant was found in possession of, among other things, a loaded privately manufactured 9mm pistol, ghost gun, fitted with a homemade silencer. Ballistics testing of the weapon confirmed that it had fired the shell casings recovered at the scene of the murder. Compl paragraph 8. The acquisition, retention, and concealment of this self-engineered weapon further underscore the planning the defendant undertook to carry out this killing. The defendant was also found in possession of a notebook containing handwritten entries dating back to August 2024. Among them was an October 22, 2024 entry openly describing his intent to whack the CEO of a health insurance company at the company's investor conference. ID. Other entries revealed a hostility toward the health insurance industry and specific references to United Healthcare and its CEO, reflecting a developed motive and careful consideration of a target. Finally, surveillance video produced in Rule 16 discovery captured the defendant following the victim to his hotel in the days leading up to the murder. USAO 3807-3817, USAO 4117. This surveillance activity was plainly designed to study the victim's movements and identify an opportunity to carry out the attack. Taken together, the defendant's early travel to New York under a false identity, possession of a loaded ghost gun, contemporaneous writings expressing intent to commit the murder, and pre-attack surveillance of the victim, leave no doubt that the crime was the product of substantial planning and premeditation. Accordingly, the defendants claim that the government's notice simply repeats statutory language and that the government has failed to identify the acts that constitute planning and premeditation is meritless when read in light of the complaint. Rule 16 discovery, and the contemporaneous documentation of the defendant's own words and conduct. Def. Mem. 1011. These materials make plain which acts the government will prove and how those acts demonstrate planning and premeditation. It identifies the victim, the timeline, and the specific conduct, use of a false identity, possession of an untraceable firearm, written declarations of homicidal intent, and targeted surveillance, that together establish the aggravating factor under 18 U.S.C. Section 3592, c. 9. The government's notice is more than sufficient under the law and due process principles, and the defendant has otherwise been provided with substantial additional detail about the government's proof of this factor. 3. Victim impact. The defendant's contention that the government's notice of intent provides no facts in support of the non-statutory aggravating factor of victim impact is similarly misplaced. Def. Mem. 1213. The facts of this case make clear why victim impact evidence will be particularly probative. Thompson was not a random passerby. The defendant hunted Thompson down to kill him because Thompson was the CEO of a major health insurance company. That is, Thompson was the leader of a company in an industry that the defendant was fixated upon harming. Entries in the defendant's notebook dating back to August 2024 reveal a growing fixation on the health insurance industry and, specifically, on United Healthcare. By October 22, 2024, the defendant was writing explicitly about his intent to whack a health insurance CEO at an investor conference. Compl paragraph 8. That fixation culminated in the surveillance of Thompson in the days and weeks leading up to his murder, and finally in the carefully planned killing itself, which was carried out on a busy midtown Manhattan street at a time of day when others were present and exposed to risk. The consequences of Thompson's murder are profound. He was a husband, a father, a colleague, and a leader whose death left a devastating void in his family, his community, and his workplace. At the penalty phase of this case, the government will present evidence showing how Thompson's death affected his loved ones. The very fact that the defendant plotted for months to assassinate Thompson because of his professional role underscores that the effects of this crime extend beyond Thompson's immediate family to his friends, co-workers, and the broader community he led. This is precisely the type of victim impact evidence that Congress authorized the jury to consider under the FDPA. See, for example, United States v. Written, 610F, 3D 168, 187-88, 2DC 2010, a fact finder should be allowed to measure the specific harm the defendant caused by committing the murder, a phrase broad enough to embrace the loss felt by friends or co-workers who were close to the victim. Quoting Payne v. Tennessee, 501 U.S. 808, 825, 1991, the law does not require the government to disclose, at this stage of the case, which family members, friends, or colleagues will testify or preview the precise nature of their loss. The notice properly identifies the aggravating factor, and the facts already in the record demonstrate the relevance and seriousness of victim impact evidence in this case. 4. Future dangerousness. The non-statutory aggravating factor of future dangerousness is fully warranted here because the evidence shows that the defendant represents an ongoing threat to the safety of others, whether in the community or within a custodial environment, and that his crime was motivated not by personal animus, but but by a broader intent to send a message and inspire hostility toward an entire industry. The defendant's writings make clear that the murder of Brian Thompson was conceived not simply as an act against one individual, but as a strike against the healthcare industry as a whole. The defendant wrote, for instance, "The target is insurance because it checks every box." Paragraph 8. This investor conference is a true windfall, and, most importantly, the message becomes self-evident. ID. Other notebook entries refer to how the murder would be a real blow to the company financials. USAO 10543 USAO 11308. The defendant's capacity for future dangerousness is further demonstrated by the careful steps he took to prepare for the attack and plan his escape. He travelled from another state under a false identity, secured lodging with a forged identification, surveilled Thompson in the days before the murder, wore a surgical mask for days on end, nearly without exception, to hide his identity, armed himself with a homemade ghost gun. These actions show not only the deliberate planning of this murder, but also the defendant's ability to deceive, to acquire lethal weapons through unlawful means, and to evade detection. Those same characteristics make him exceptionally dangerous in the future. Just as importantly, and as discussed above, the context and execution of the murder strongly suggest that the defendant intended to influence or provoke broader reactions beyond the immediate killing. He wrote deny, depose, and delay on the bullets he used to kill Thompson, knowing that the shell casings would likely be found by investigators and that this message, associated with criticism of the healthcare industry, would be widely disseminated in media coverage. 2. He assassinated the CEO of one of the largest health insurance companies in the country on a busy midtown Manhattan street during the morning commute. In doing so, he not only endangered multiple bystanders but also maximized the public visibility of his crime. The defendant wrote of the message he hoped this killing would convey. Paragraph 8. The murder was thus, by the defendant's own admission, calculated to resonate beyond this specific victim and to generate scorn, outrage, or fear toward the health insurance sector more broadly. Simply put, the defendant hoped to normalize the use of violence to achieve ideological or political objectives. Since the murder, certain quarters of the public, who openly identify as acolytes of the defendant, have increasingly begun to view violence as unacceptable or even necessary. 2c. For example, Dan Mangan, deny, defend, depose. United Healthcare CEO killing shell casings had words written on them. CNBC, December 5, 2024, available at https://www.cnbc.com/the5th of December 2024/deny defend depose United Healthcare CEO shooting shell casing Thompson HTML. See also words on ammo in CEO shooting echo common phrase on insurer tactics, delay, deny, defend. Associated Press, December 5, 2024, available at https://appnews.com/article/United Healthcare CEO shooting delay deny defend depose E73 Seb 19 F361835 C654 F04 3B88 C50. For reason political disagreement. 3. The defendant poses a continuing danger not only in a personal capacity, but also because he has sought to influence others. 4. The factual support for this aggravator is already within the defendant's possession. It includes his notebook and other pieces of evidence produced in discovery, as well as facts that are in the public record. 5. The cases cited by the defendant are distinguishable, although the defendant relies on several district court cases in which the production of an informational outline was ordered. Those rulings were highly fact-specific and carry little persuasive weight when contrasted with the contrary authority from the circuit courts cited above. Those cases also represent a minority position, particularly at this stage of the proceedings. The vast majority of district courts have rejected motions for informational outlines, or bills of particulars, relating to penalty phase evidence. See Supra pages 4-8. Moreover, while there may be some divergence among district court decisions, every court of appeals to have addressed the 3C wanted CEO posters and other threats emerge after Mangione arrest. NBC News, December 11, 2024, available at https www.nbcnews.com/news/us/wanted posters threats Mangione arrest United Healthcare RCNA 183,867. On July 28, 2025, Shane Tamura brought an assault rifle to a Manhattan office building, a short distance away from where Mangione had killed Thompson. Tamura shot and killed 4 people, including an off-duty police officer, an executive of a financial services firm, and a security guard, and he injured others, including an employee of the National Football League, NFL. Like Mangione, Tamura left behind a piece of evidence for investigators to find, blaming the NFL and football for causing chronic traumatic encephalopathy. Almost immediately, members of the public sympathetic to the defendant touted Tamura's actions as a laudable continuation of the defendant's philosophy. See, for example, Tracking Luigism Online, City Journal, August 14, 2025, available at https://www.city-journal.org article/Wesley Lepatner Manhattan shooting Shane Tamura Luigi Mangione, summarizing evidence that the defendant's supporters claimed that Tamura was following in the footsteps of Mangione. Following his arrest, the defendant openly cultivated supporters. He has set up a website, on which he has directly addressed his supporters, and which includes a section for frequently asked questions with questions like may I send him items like books, can I send Luigi photos, and what else can I send Luigi? See luigimangoneinfo.com. The same website contains scanned images of an index, prepared by the defendant himself, exhaustively cataloguing all of the supportive letters he has received. These are actions for which the defense needs no disclosure, because they are the actions of the defendant himself. Including the 4th, 8th, and 11th Circuits, has held that the government is not required to provide an informational outline or bill of particulars for aggravating factors. See, Lecroy, 441F, 3D 914, Higgs, 353F, 3D 281, Lee, 274F, 3D 485, Battle, 173F, 3D 1343. Notably, several of the cases cited by the defendant do not support the proposition he advances and are drawn from cases that are factually distinct from the instant case. For example, the defendant cites to the court's decision in United States v. Sapov, 17 CR 722, DKT, number 482, SDNY August 11, 2022, as an example of a court in this district ordering the government to produce an informational outline of what it intends to prove at the capital phase of the defendant's case. However, the defendant misstates the holding in Sapov. Judge Broderick did not order the government to provide an informational outline. In the circumstances of that specific case, the government had previously agreed to provide such an outline similar to the one provided in United States v. Bin Laden, 126 F sub 2D 290, SDNY 2001. The focus of the litigation surrounding the informational outline was timing, and Judge Broderick's order simply expedited the timing of the government's production of the outline. See United States v. Sapov, case number 17 CR 722, DKT, number 472, Gov. Memorandum of Law in support of its motion in limine, at 2935, SDNY August 5th, 2022. Ultimately, the government provided its outline several weeks prior to the scheduled trial date. Accordingly, Sapov holds little precedential value for the defendant's request in this case. The defendant's reliance on Bin Laden is similarly misplaced. That case involved an extraordinary number of victims, and the government's notice there contained only an oblique reference to the victim's injuries, harm, and loss. Bin Laden, 126 F sub 2D at 304. By contrast, this case involves a single victim, and the scope of harm limited to the victim's family, friends, and co-workers is both clear and substantial, particularly given the victim's role as CEO of a large national health insurance company. Division in United States versus Lara Plaza, 179 F sub 2D 464, 472, EDPA 2001, is also distinguishable. In Lara Plaza, the court confronted a complex indictment involving 3 defendants and 15 murders committed over several years, thereby introducing a vast web of factual intricacies to be navigated in evaluating the applicable aggravating factors. Here, however, the defendant is charged with a single murder of a single victim on a single day with a single weapon. The other cases cited by the defendant similarly turn on their unique facts, often reflecting district courts granting limited requests for additional detail with respect to certain aggravating factors while denying others. Def. Mem. 8-9. None of these decisions is controlling, and none undermines the precedential weight of the circuit court rulings cited above or the persuasive value of the many district court decisions rejecting similar requests. Indeed, at least one court in this district has expressly denied a motion for disclosure of penalty phase evidence. See United States v. Williams, 00CR 1008, NRB, 2004 WL 2,980,027, at Star 23, SDNY December 22, 2004, denying request for written statement describing the proposed testimony of each victim impact witness. Once the court sets a trial date, and to the extent any genuine uncertainty remains in the lead-up to trial, the need for further disclosures can be revisited. The defendant's request now is plainly premature and is otherwise without merit for the reasons detailed above. In short, the case law does not support the defendant's position. The notice here complies with the FDPA and provides the defendant with all that is legally required. In seeking additional particulars, the defendant overlooks the detailed information already set forth in the charging instrument and discovery. His motion should therefore be denied. Conclusion: for all of the reasons set forth above, the defendant's motion should be denied. Dated, New York, August 27, 2025. Respectfully submitted, Sean S. Buckley, attorney for the United States, acting under authority conferred by 28 U.S.C. Section 515 by Perez Padat, Dominic A. Gentile, John Ziang, Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys.
Basically, the prosecutors give 2 reasons why this motion should be denied. The first reason they say is basically they said they give enough evidence to Luigi Mangione's legal team. In reality, they haven't. They need to give everything over, not just majority of it. And then the second reason why they think Luigi Mangione's motion should be denied is have enough evidence to put the death penalty against Luigi Mangione. In reality, they don't. Again, I've discussed this many times before in the past. They have to do many different things before they can actually have the death penalty put against someone, instead of what they actually have and just announced it, if that makes sense. And basically in this document, it is very much them just trying to pull things out of their asses, allegedly. And we will see this more and more as we go on. They keep placing more and more things against Luigi Mangione, and I think it's very much because his trial is coming up soon. Not up to that part in the video, but I very much noticed that when I was gathering information for this video and his trial was coming up, more and more things were coming out and being put against him. And again, that's not fair, I think. My opinions anyway, and I think a lot of other people agree with me. 28th of August 2025. So basically, but this is another document explaining why Luigi Mangione doesn't want to do all the Pennsylvania court appearances through Zoom, and Luigi Mangione does have the right to be there in person. But please take these documents with a little bit of skepticism. I did get these from Instagram. I did try to find these actual documents. I could not find them anywhere. But if you guys do know where you could find these actual documents, please send them to me. I would love to see them. But in my case, I can't see them. This is fun working in an American case where I don't have access to a lot of documents. So I live in a different country. This has been fun. Very annoying, I think, anyway. It's for the greater good. It's for Luigi. So I'll put the document up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania, Criminal Division, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, Defendant. Notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and Presite for consent to remote appearance, filed on behalf of Commonwealth of Pennsylvania Peter J. Weeks, Esquire District Attorney PA, ID 201,051 Nicole M. Smith, Esquire First Assistant District Attorney PA, ID 200,855 Office of the District Attorney, Blair County Courthouse 423 Allegheny Street, Suite 421 Hollidaysburg, Pennsylvania 16648, 814-693-3010 Counsel of Record, Thomas M. Dickey, ESQ. Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. Luigi Nicholas Mangione, Defendant. Notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and Presite for consent to remote appearance, and now comes the Commonwealth of Pennsylvania by and through the District Attorney's Office of Blair County, and files this notice of defendant's unavailability for personal appearance in the Blair County Court of Common Pleas and Presite for consent to remote appearance, and in support thereof avers the following. 1. Defendant, Luigi Nicholas Mangione, Defendant Mangione, was charged at the above captioned criminal action numbers with forgery, utters forged writing, 18 PACSS 4101A3F3, firearms not to be carried without license, 18 PACS $6,106A1, tamper records or identification, writings, 18 PACS $4,104A, possess instrument of crime, 18 PACS $907, and various related criminal offences to, on or about December 19, 2024, Defendant Mangione elected to waive his preliminary hearing with a preservation of habeas and then waived extradition to the state of New York, where he faces homicide, and related waivers would cause him to be removed from the jurisdiction of Blair County in order to first prosecute him on his homicide case. The undersigned served a subpoena by email and hand service to secure defendant Mangione's appearance after his homicide prosecution. Notably, the logistics and costs for the transportation and housing of defendant Mangione were significantly greater than a typical inmate due to the media and public attention generated by the New York allegations. Further, there were significant security concerns regarding the custody and transportation of defendant Mangione due to the public attention the case has received and the threats received by the criminal justice system regarding defendant Mangione's prosecution. Subsequent to defendant Mangione's custody being transferred from the Blair County Sheriff to the New York City Police Department, he was taken into custody by the United States government on a federal indictment for homicide and related charges. Consequently, defendant Mangione was detained in a federal prison where he remains. The undersigned has been in communication with Assistant United States Attorney Frank Balsamello and the other United States attorneys prosecuting defendant Mangione for the purposes of providing discovery to the United States government and to ascertain whether defendant Mangione would be physically available for court appearances in Blair County during the pendency of his federal prosecution. On or about February 12, 2025, the undersigned received a letter from the United States Attorney's Southern District of New York, which indicated that defendant Mangione would not be made physically available to Blair County until the disposition of his federal charges, including any sentencing proceedings. The letter also indicates that defendant Mangione will be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. The Commonwealth received defendant Mangione's prescribed to schedule hearing and demand for personal appearance on or about June 20th, 2025 and immediately reached out to the federal prosecutor's office in New York. On or about June 20th, 2025, the undersigned received a letter from the United States Attorney's Southern District of New York, which indicated that defendant Mangione would not be made physically available to Blair County until the disposition of his federal charges, including any sentencing proceedings. The letter also indicates that defendant Mangione will be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. Subsequent to this correspondence and at the demand of defendant Mangiane's attorney, who repeatedly has declined to allow defendant Mangione to participate remotely, the Commonwealth filed a petition for writ of habeas corpus ad prosequendum with the court. It is believed that the writ is still pending signature. Notably, the Commonwealth has been advised that the writ will ultimately be denied. The court has ordered the Commonwealth to provide an additional update on the availability of defendant Mangione on or before August 22, 2025, and the same is addressed by this notice. The position of the United States Attorney's Office regarding the physical unavailability of defendant Mangione has made defendant Mangione unavailable pursuant to PAR, Crim P. 600. The Commonwealth's detainer and pending writ of habeas corpus ad prosequendum reflects its intent to secure defendant Mangione once he is physically available for prosecution in Blair County. Wherefore, the Commonwealth of Pennsylvania respectfully requests this Honourable Court to enter an order acknowledging receipt of the attached correspondence and defendant Mangione's unavailability pursuant to PAR, Crim P 600 unless defendant Mangione elects to appear via video conferencing. Respectfully submitted. Peter J. Weeks, Blair County District Attorney, Blair County District Attorney's Office, 423 Allegheny Street, St. 421 Hollidaysburg, Pennsylvania 16648, 814-693-3010. Respectfully submitted. Nicole M. Smith, First Assistant District Attorney, Blair County District Attorney's Office. Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. Luigi Nicholas Mangione, Defendant, CP07CR0002724-2024 Certificate of Service X, Peter J. Hooks, District Attorney, do hereby certify that I have served on this day a true and correct copy of the foregoing motion via email to Thomas M. Dickey, Esquire, ESG 308 Orchard Avenue, Altoona, Pennsylvania 16602 date, August 21, 2025. Phil Peter J. Weeks, ESQ, for the Commonwealth. In the Career of Common PIEAS of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. Luigi Nicholas Mangione, Defendant, CP07CR0002724-2024 Certificate of Compliance. I certify that this filing complies with the provisions of the Public Access Policy of the Unified Judicial System of Pennsylvania. Case records of the appellate and trial courts that require filing confidential information and documents differently than non-confidential information and documents. Respectfully submitted. Peter J. Weeks, District Attorney.
Lol, I literally just got a text message from my sister about Luigi Mangione. I know, I'm there. Lol. I'll bring that up later on in the video about something else that was funny. Give me a minute, I need to text her. I just got a message back to her going, yeah, I know you were there. I do feel sorry for my sister. I tell her too much about this case. Against her will. Sometimes I want someone in person to yap about this case. Other than Reddit and here. This is why I have you guys. So I can yap about this case as much as I want. Anyway, I'm moving off topic. The 3rd of September 2025. So basically this is a document from the prosecutors about the psychiatric evidence. I'll put it up on screen for you guys and this is what their response to it is.
People vs. Luigi Mangione Indictment No. IND 75657. 24 Dear Judge Caro, on June 17, 2025, this court directed the defense to provide written notice pursuant to CPL 250.10 by August 25, 2025, whether they intend to introduce psychiatric evidence of the defendant's mental disease or defect. Instead of complying, on the day notice was due, the defense filed a letter seeking an indefinite extension and volunteering to share the reasons for that request with the court ex parte. The defense's request should be denied, and they should promptly comply with the notice requirements of CPL 250.10. An ex parte proceeding appears to be unnecessary, given the absence of any factual or legal basis for it, as well as the absence of any explanation for why the defense waited until 8 months after arraignment to request such a proceeding. As to the reasons cited in defendant's letter, defendant claims that he cannot decide whether to pursue a psychiatric defense until the completion of discovery, but nothing in CPL 250.10 2, which requires notice no more than 30 days after a defendant's entry of a not guilty plea, keys the timing of the required notice to the completion of discovery, and in any event, defendant has already received the bulk of the discovery in this case, and the limited number of outstanding discovery items such as the contents of the victim's cell phone, which the people are still reviewing to determine what is properly discoverable, have no bearing on any potential psychiatric defense. Furthermore, defense counsel has unfettered access to the defendant and to psychiatric records, if any, beating on any such defense. The numerous terabytes of discovery materials that have already been provided, as well as counsel's unique access to relevant evidence as to the defendant's state of mind, have provided her with more than adequate information during the 8-month period since arraignment to make a reasoned determination. Next, defendant reiterates an argument previously made in his omnibus papers that compliance with CPL 250.10 would somehow violate his constitutional rights because of his pending federal prosecution. As the people have previously explained, it would be contrary to law and to logic to delay the state trial indefinitely to an unknown future date several years down the line. See People's Omnibus Response, pages 45-56. Because there is no merit to defendant's argument, the state trial must proceed on an ordinary timeline, including requiring, as the court has, that the defense comply with their notice obligations. In our system, a jury of a defendant's peers decides the guilt or non-guilt of the defendant based upon a dispassionate review of the body of evidence. Unnecessary delay thwarts the timely search for truth and erodes public confidence in the justice system. Just as a defendant is entitled to a speedy resolution of the charges lodged against him, so are the people. The undesirable effect of ignoring the court's order regarding CPL 250.10 notice is to delay the scheduling of a trial. In so doing, the defendant would deprive the people of their day in court at a time when the events are fresh in the witnesses' memories. Wherefore we respectfully request that the defendant comply with the court's order to provide notice pursuant to CPL 250.10 and that the court adjourn the case for hearing and trial. Sincerely, Joel I. Werman, Joel J. Siedelman, Senior Trial Counsel, Assistant District Attorney 212-335-4186 Karen Friedman Agnifilo.
Basically, the prosecutor's response to Luigi Mangione's motion for them to have more time about having the psychiatric evidence is they are very dismissive about Luigi Mangione's case. Like, they're literally treating this like a normal everyday case, and in reality it is not like that whatsoever. So I got this quote from one of the Instagram pages I follow getting updates for the Luigi Mangione case. I do recommend to follow these guys, and I do very much agree with this comment they made. So the Instagram page I recommend to follow. I recommend you guys to go follow them. They do a lot of good updates on Luigi Mangione's case, a lot more than I do. Put them down below if you guys want to follow them. So they are justice for Luigi, but like instead of the word for, it is literally the number 4, so I recommend to go follow them. They do lots of good updates on Luigi Mangione's case. This is a quote they did when this came out, and I do very much agree with this quote, so I'll put it up on the screen for you guys.
Prosecution's response is dismissive. They treat Luigi's situation like a routine case, when in reality he faces 3 cases with unprecedented dual prosecutions and the DP.
So this is another thing that came out on the same day, and normally I would leave this kind of stuff later on in the video where it's like things aren't really related to his case but are important, or I think I should bring up, but this very much was a big thing and I do think I want to add this here. So basically Shein, you know, the website where you can buy a lot of clothing but really cheaply, they basically used Luigi Mangione's face just to sell t-shirts. This was so big, my sister sent me a message about this, and she doesn't know anything about this case, and that's the things I force feed her. I'm sorry. I just want someone in person to talk about this case. I know Shein has had problems in the past with like stealing other people's art, but this is something way fucking bigger and way more disgusting and scummy to use Luigi Mangione's face to sell t-shirts that, I might add, this isn't his actual face. This is a AI picture of his face put on, say, a model or something like that. It's very disgusting and gross for them to do that. This kind of stuff happens when another court appearance for Luigi Mangione. A lot more things like this will come up, but this is more disgusting and scummy to make a profit out of his face and his likeness. So, and if you guys haven't seen the photos, I'll put them up on screen for you guys. So those are the photos of basically Shein using Luigi Mangione's likeness to sell t-shirts. Also, I did try to find these photos of Luigi Mangione on like Shein in Australia, but I could not find them whatsoever. So I think it was very much just a American thing than here in Australia, because you know, different countries have like different Shein things, if that makes sense. But I did try to find them here in Australia on Shein, but I could not find them. Apparently the t-shirts did sell out, but it's still a very disgusting and scummy thing for them to do that. Like, they've stolen people's art in the past, and that's scummy for them to do that, but they've now done this, real human beings' likeness, to sell t-shirts and make a profit. It is very disgusting, I think, anyway. I have a little bit of beef with Shein at the moment. Something personal with me with Shein, and now this, I have like a problem with Shein right now. I don't like them, okay? They were okay in the past for me. Please don't yell at me. Poor people are allowed to look nice. Okay, I'm just gonna say that here. But I have a problem with them now, and now this on top of that, I have beef with them right now. Getting pins and needles in my legs. I need to stop making these videos on the floor. Not really for my legs. The 4th of September 2025. 4th of September 2025. This is literally the next day. Basically, Thomas Dickey did a interview talking about it is very disgusting of Shein to use Luigi Mangione's likeness to basically sell t-shirts. He did do a interview, so I will put it up on the screen for you guys. It only goes for a couple of seconds, so I won't do the thing what I normally do, where I do some of the video and then basically do the transcript for the rest of the video. I'll just play you guys the full video. Again, it only goes for a couple of seconds, so we did do an interview. I wish they had the full interview of what he said, but they only had the short clip of what Thomas Dickey said in that interview, so I'll put it up on the screen for you guys.
Mangione's lawyer, Thomas Dickey, was shocked to see the ad.
Mr. Mangione did not authorize that. I wasn't happy to see somebody, using his image or likeness for their own, monetary gain, period, let alone without his permission.
5th of September 2025. This is another document from the prosecutors. So I'll put up on the screen for you guys.
United States District Court, Southern District of New York, ex-United States against 25 CR 176, MMG, Luigi Mangione defendant, ex-reply in support of motion for informational outline of certain aggravating factors. The defendant Luigi Mangione respectfully submits this reply brief in further support of his motion, seeking an informational outline. In its brief in opposition, the government contends that the law does not require it to provide such information to the defense, stating that the overwhelming majority of courts have consistently rejected such demands. While it is true that the Federal Death Penalty Act does not explicitly require the government to provide an informational outline, the overwhelming majority of courts, including every district court in this circuit that has considered the issue, have found that due process requires the government to provide a defendant in a capital case with sufficient notice of aggravating factors so that he is able to respond and prepare his case in rebuttal. 1. Due process requires the government to provide an informational outline in United States versus Gendron, 2024 WL 3,647,779, WDNY August 2, 2024, the court rejected exactly the arguments advanced by the government in this case and ordered the government to provide an informational outline, stating, "New capital case, the government must give the defendant notice of all aggravating factors sufficient to enable the defendant to respond and prepare his case for sentencing." For example, United States versus Kaczynski, 1997 WL 34,626,785, at star 18, ED Cal, November 7, 1997, United States versus Lara Plaza, 179 F sub 2D 464, 472, EDPA 2001. This right to notice necessarily flows from a defendant's due process right to defend against the government's case. C. Kaczynski, 1997 WL 34,626,785, at star 18, Lara Plaza, 179 F sub 2D at 472. As noted above, a case seeking the death penalty can include broadly worded aggravating factors and myriad facts that might not be admissible in most trials. C. 18 U.S.C. Section 3593, C. What is more, T. The severity of the penalty sought warrants special efforts to ensure the fairness of the proceedings. United States versus Lujan, 530 F sub 2D 1224, 1269, DNM 2008. So to provide sufficient notice, the government must inform the defendant of the theories and facts that it will use to establish each aggravating factor. Lara Plaza, 179 F sub 2D at 472, ID, at star 2. Further noting that an informational outline assists the court in performing its function as an evidentiary gatekeeper in screening the aggravating factors and the evidence permitted in attempting to prove them. The court concluded that courts may use their inherent authority to order the government to provide additional information about aggravating factors in capital cases ID, Accord. United States versus Kaczynski, 1997 WL 34,626,785, at star 19, United States versus Lara Plaza, 179 F sub 2D at 473.75, United States versus Rodriguez, 380 F sub 2D at 1058, Lujan, 530 F sub 2D at 1269-72, United States versus Hammer, 2011 WL 6,020,157, at star 3, United States versus Wilson, 493 F sub 2D 364, 378, EDNY 2006. United States v. Bin Laden, 126 F sub 2D 290, 304.05, SDNY, 2001, United States vs. Savage, 2013 WL 1,934,531, star 11, star 21, EDPA, May 10th, 2013, United States vs. Schlesinger, 2021 WL 5,578,901, at star 34, Dieras, November 30th, 2021, United States vs. Con UI, 2016 WL 9,331,115, at star 1719, MDPA, January 28th, 2016, United States vs. Glover, 43 F sub 2D 1217, 1222, pages 1224-28, D. Kansas 1999, United States vs. Cooper, 91 F sub 2D 90, 111, DDC 2000, United States vs. Gooch, 2006 WL 3,780,781, at star 23, DDC December 20th, 2006, United States v. Duncan, 2008 WL 656,036, at star 78, D. Idaho March 6th, 2008, United States vs. O'Reilly, 2007 WL 4,591,856, at star 5, E.D. Mitch, December 28th, 2007, United States vs. Diaz, 2007 WL 4,169,973, at star 3, N.D. Cal, November 20th, 2007, United States v. Bin Laden, 126 F sub 2D 290, 304.05, SDNY, 2001, United States vs. Sapov, case number 17 CR 722, docket item 472 at 2930, SDNY August 5th, 2022, docket item 482 at 1, SDNY August 11th, 2022. Thus, for example, in U.S. versus Kaczynski, 1997 WL 34,626,785, ED Cal, November 7th, 1997, the court, in ordering the government to provide an informational outline with respect to several of the aggravating factors in the government's notice of intent stated, despite the fact that the notice need not comply with the strictures of Rule 7, it must nonetheless survive constitutional scrutiny. While many of the safeguards incident to criminal prosecutions do not apply to the sentencing process, it is axiomatic that due process principles must be satisfied. C. Clemens, 494 U.S. at 746, Gardner versus Florida, 430 U.S. 349, 358, 97 S, CT 1197, 51 L, ed. 2D 393, 1977, the defendant's ability to defend against the case presented by the prosecutor, which includes advocating for a particular punishment, is one of the hallmarks of due process. C. Simmons versus South Carolina, 512 U.S. 154, 175, 114 S, CT 2187, 129 L, ed. 2D 133, 1994, O'Connor, J., concurring. Moreover, a defendant must not be sentenced to death on the basis of information which he had no opportunity to refute, i.d., quotations and citations omitted. Therefore, at a minimum, due process requires a defendant to receive sufficient notice of aggravating factors to enable him to respond and to prepare his case in rebuttal. In evaluating whether due process is satisfied, the death penalty notice must be considered in conjunction with the offences as charged in the indictment, which can provide the requisite specificity to an otherwise insufficient notice. ID, at star 18. See also, United States versus Duncan, 2008 WL 656,036, at star 5, D. Idaho March 6, 2008, United States versus Rodriguez, 380 F, sub 2 D 1041, 1057, DND 2005, United States v. Bin Laden, 126 F sub 2 D 290, 30405, SDNY, 2001, an oblique reference to victim's injury, harm, and loss, without more, does nothing to guide defendant's vital task of preparing for the penalty phase of trial. U.S. versus Wilson, 493 F, sub 2 D 364, 378, EDNY 2006. The category of victim impact is vast. The defendant is entitled to have some sense of how this will be proved, an aggravating factor that the jury could consider in coming to an individualized determination on the basis of the character of the individual and the circumstances of the crime of whether Wilson should receive a death sentence. United States versus Sapov, case number 17 CR 722, docket item 472 at 2930, SDNY August 5th, 2022, docket item 482 at 1, SDNY August 11th, 2022, 2. The information contained in the notice of intent is inadequate in seeking to deny the defense the information that it needs to prepare properly for a potential penalty phase. The government further contends that the defendant has received adequate notice of each aggravating factor, but that contention is false. The government's notice of intent cites two statutory aggravating factors: grave risk of death to additional persons and substantial planning and premeditation, but does not include any information concerning the individual or individuals who allegedly were put in grave risk of death by Mr. Mangiane's alleged actions. Nor does it contain any information regarding the actions that the government alleges constitute substantial planning. Indeed, with respect to the two statutory aggravating factors cited by the government in its notice of intent, the government did nothing more than quote the language of the statute regarding the charged aggravating factor. The government stated that because the shooting is alleged to have occurred on a public street in Midtown Manhattan, directly adjacent to a major New York City hotel, during the early morning hours when people were commuting to work, that is sufficient to justify the statutory aggravating factor of grave risk of death to additional persons Under this logic, the government is suggesting that every shooting on the streets of Manhattan would satisfy this statutory factor, which fails to narrow the type of cases in which the death penalty would be appropriate. Respect to the non-statutory aggravating factors of victim impact and future dangerousness, the lack of useful information is even more problematic. The discovery produced by the government does not provide any indication as to how the government intends to prove those two aggravators and what evidence it intends to rely on. With respect to victim impact, the notice of intent simply alleges that Mr. Mangione caused injury, harm, and loss to the family, friends, and co-workers of Brian Thompson. The injury, harm, and loss caused by Mangione with respect to the victim is evidenced by the victim's personal characteristics and by the impact of the victim's death upon his family, friends, and company workers. The loss of a loved one is of course always both tragic and traumatic to a victim's family and friends. However, to constitute an aggravating factor to support a death sentence, the defense needs more than what is self-evident in every homicide. The notice does not indicate which family members or co-workers were harmed, what personal characteristics of Mr. Thompson are referred to, or the nature of the impact caused by his death on the alleged victims. The victim impact language in the notice of intent in this case is virtually identical to the language charged in Gendron, Supra, where the government alleged that the defendant caused injury, harm, and loss to the families and friends of the victims. The injury, harm, and loss caused by Gendron, with respect to each victim, is evidenced by the victim's personal characteristics and by the impact of the victim's death upon his or her family and friends. The court in Gendron found that notice to be insufficient and ordered the government to provide an outline with the personal characteristics it intends to prove as to each victim, the identities of the people whom it intends to prove were affected, and the type and scope of the loss, injury, and harm suffered. 2024 WL 3,647,779 at star 5. See also, U.S. v. Glover, Supra, 43F, Sub 2 D 1217, 1225, Decan 1999. The court finds that the defendant is entitled to greater specificity regarding this factor, to wit, which members of the family have suffered, the nature of their suffering, and the nature of the permanent harm, for example, whether members of the family sought counseling or other medical treatment, such as hospitalization, and whether and to what extent members of the family suffered financial harm, are relevant considerations in discerning whether this factor is indeed aggravating in this case. U.S. v. Lera Plaza, Supra, 179F, Sub 2D 464, 475, EDPA 2001, in order to allow the defendants to adequately prepare responses to sentencing phase evidence, and in order to allow the court to determine if a pre-sentencing hearing will be necessary to review the evidence, the government will be ordered to submit an outline of its proposed victim impact evidence, U.S. v. Bin Laden, Supra, U.S. v. Wilson, Supra, with respect to future dangerousness. The notice of intent alleges that Mr. Mangione presents a future danger because he expressed intent to target an entire industry and rally political and social opposition to that industry by engaging in an act of lethal violence, and he took steps to evade law enforcement, flee New York City immediately after the murder, and cross state lines while armed with a privately manufactured firearm and silencer. The notice does not indicate when and where Mr. Mangione expressed an intent to target an entire industry or how he intended to target an entire industry. To the extent that the notice alleges that Mr. Mangione expressed an intent to rally political and social opposition to that industry, that is, the health insurance industry, that does not make him a future danger, but rather simply indicates that he intended to exercise his First Amendment rights. In fact, Mr. Mangione never stated anything publicly, released anything publicly, or expressed anything online to suggest this was his intention. Law enforcement, prosecutors, and the mayor of New York City are solely responsible for the very fear they are now attempting to attribute to Mr. Mangione. As for evading law enforcement and traveling across state lines with a firearm and a silencer, those facts are relatively common in homicide cases and thus fail to narrow the type of cases in which the death penalty would be appropriate. Finally, it should also be noted that upon information and belief, United Healthcare historically received numerous threats that predate the 4th of December, 2024. Thus, the defence is entitled to understand the scope of what the government will attribute to Mr. Mangione to justify his execution. Recognising the weakness of this aggravating factor and in an attempt to justify its inclusion in the notice of intent, the government, in its opposition brief, alleges that Mr. Mangione represents a continuing threat to public safety because the murder he allegedly committed was motivated not by personal animus, but by a broader intent to send a message and inspire hostility toward an entire industry. Even if true, the defendant's alleged intent to call attention to the abuses of the health insurance industry in denying or delaying needed medical services does not prove that he was advocating the use of violence against other members of the health insurance industry in the future. Indeed, there is not a shred of evidence in the terabytes of discovery produced by the government to date that indicates that Mr. Mangione was advocating the use of violence by others against members of the health insurance industry or anyone else for that matter. It is precisely because the discovery produced to date does not provide any evidence that Mr. Mangione presents a future danger to public safety that the defence is asking that the government be required to provide an informational outline, indicating how it intends to prove this aggravating factor. To further support their position that Mr. Mangione poses a future danger, the government directs the court to a website created by counsel, www.luigimangioneinfo.com, as somehow evidence that he poses a future danger. This website was created by counsel, guided case 125 CR 00176 MMG document 46, filed the 9th of May 2025, page 7 of 10 by Federal Rule 23.1, to dispel misinformation and efficiently address the NUM. Federal Rule 23.1, to dispel misinformation and efficiently address the numerous daily requests we receive from members of the public and press regarding the 3 simultaneous prosecutions Mr. Mangione faces. Additionally, numerous United States Bureau of Prisons web pages became inactive following January 20th administration transition, leaving a void of information on proper processes. Counsel wanted to ensure that members of the public were following proper legal procedures to reduce any imposition on Bureau of Prison staff. Since his arrest and predating the launch of this website more than 2 months later, Mr. Mangione has received thousands of unsolicited letters from all over the world. This outpouring of support has created an understandable backlog for the Bureau of Prisons, causing Mr. Mangione to often receive letters months after they were sent. A frequently asked question to counsel is whether Mr. Mangione has received a particular correspondence. To address this backlog issue, a simple mail catalogue was created to inform the people who take the time to write to Mr. Mangione so they can see whether their letters were read. Most alarmingly, and in an attempt to prejudice potential jurors and thereby Mr. Mangione's right to a fair trial, the government, in its opposition brief, attempts to link him to other recent killings, including the recent murder of 4 people in Manhattan by Shane Tamura, writing that, since the murder, certain quarters of the public, who openly identify as acolytes of the defendant, have increasingly begun to view violence as an acceptable, or even necessary substitute for reasoned political disagreement. The defendant poses a continuing danger not only in a personal capacity, but also because he has sought to influence others. The government is well aware that there is absolutely no link between Mr. Mangione and Mr. Tamura, and there is no evidence that Mr. Tamura was influenced in any way by the murder of Mr. Thompson or by Mr. Mangione's writings criticizing the abusive practices of the health industry that prioritize profits over the needs of the insured, and are currently under investigation by the Department of Justice. There is also no evidence that Mr. Mangione has done anything since his arrest to incite or foment violence against the health insurance industry or against anyone else for that matter. Mr. Mangione, whose emails and telephone calls are recorded and monitored by the government, has been a model inmate, working as an orderly on his unit and earning a clean disciplinary record. If the government had evidence that Mr. Mangione was advocating or fomenting violence against the health insurance industry or against anyone else for other ideological reasons, that evidence would surely have been mentioned in its notice of intent and highlighted in the government's opposition brief. The government's silence on this issue is telling and clearly shows why the defense needs an informational outline in this case. Mr. Mangione is no more responsible for the actions of Mr. Tamura or any other alleged killer whose actions followed his arrest than the president is responsible for the alleged mishandling of classified documents by those who served with him, before him or after him. In fact, Mr. Mangione condemns these very acts of violence that the government is attempting to attribute as being inspired by him. The government's attempt to link Mr. Mangione to the likes of Shane Tamura without any evidence is further proof of the political nature of the tragically unfortunate decision to seek to execute Mr. Mangione. If the government intends to prove that Mr. Mangione continues and will continue to present a danger to public safety, it should be required to inform the defense of the evidence it intends to use to prove that aggravating factor so that the defense can be prepared to refute it and to better enable this court to determine whether such evidence indeed is aggravating. For the reasons discussed above, and based on the authorities cited herein and in our initial brief, it is respectfully submitted that the court should follow the opinions of every district court in this circuit to have ruled on this issue and order the government to provide an informational outline detailing the evidence on which it intends to rely to prove the statutory and non-statutory aggravating factors alleged in its notice of intent, dated September 5th, 2025, New York. New York, Moskowitz, Colson, Ginsberg and Schulman, LLP, S. Avraham Moskowitz, Avraham C. Moskowitz, Elon Schulman, Christopher R. F. Agnifilo, Intrator LLP, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan, attorneys for Luigi Mangione II, Clerk of Court, by ECF or Counsel of Record, by ECF.
So this is a quote from Instagram about this entire document, and I think they explained it really well compared to what I can, so I'll put it up on screen for you guys.
Government's notice is vague, overbroad, and constitutionally inadequate. Without a detailed outline of how the prosecution intends to prove each aggravating factor, Luigi cannot fairly prepare for trial or meaningfully rebut the government's claims. Requiring the government to provide specifics would ensure due process, prevent trial by ambush, and uphold the heightened reliability required in a DP proceeding.
The 8th of September 2025. Again, I mentioned this at the start of the video, but this is when Luigi Mangione's legal fund URL actually changed. Again, I would normally put this kind of stuff near the end of the video with things that aren't really relating to his case, but this is important and this is when it actually happened. Again, please spread a word around about Luigi Mangione's new URL to his legal fund. Again, I'll put it in the description under below, but again, I just want to put this here. The 9th of September 2025. Do take these documents with a little bit of skepticism. I did get these from Reddit. Basically, this is a document of the prosecutors saying yes, they will send Luigi Mangione to Pennsylvania. So again, I'll put this document up on screen for you guys.
The 9th of September 2025, the 8th of September 2025, Bernard, Jackie Atherton, Blair County District Attorney's Office, the 9th of September 2025, E-Service Dickey, Thomas M. the 9th of September 2025, E-Service Bernard, Jackie Atherton served, the 9th of September 2025, the 9th of August 2025. Order directing the defendant be produced in the Court of Common Pleas the 11th of July 2025 at 1:30 p.m. See Order, Blair County District Attorney's Office, the 9th of September 2025, E-Service, Dickey, Thomas M. the 9th of September 2025, E-Service, the 9th of September 2025, the 9th of August 2025, order requesting release of defendant to Blair Company Sheriff's for hearing see Order, Blair County District Attorney's Office, the 9th of September 2025, E-Service Bernard, Jackal Atherton served.
There's another document from prosecutors basically pushing more things onto Luigi Mangione. Again, we will see Karen Agnifilo's response to this later on in the video, but I will put this document up on screen for you guys.
The Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania, No. CP 07 CR 2724-2024 versus Luigi Nicholas Mangione, Defendant Hon Jackie Atherton, Bernard Peter J. Weeks, Esquire Nicole Smith, Esquire Thomas Dickey, Esquire Presiding Judge, District Attorney, First Assistant District Attorney, Counsel for Defendant, writ of habeas corpus ad prosequendum, and now, this 8th day of September 2025, a petition for writ of habeas corpus ad prosequendum filed by District Attorney Peter J. Weeks and First Assistant District Attorney Nicole Smith, for the attendance of the defendant, Luigi Nicholas Mangione, now confined in the Metropolitan Detention Center, Brooklyn, New York is pending in the court, further having received confirmation that the defendant is not objecting to the writ of habeas corpus ad prosequendum. See Exhibit A. Entry of the following is deemed appropriate. This court certifies as follows, that 1. On December 9th, 2024, the Commonwealth of Pennsylvania, by and through the Altoona Police Department, charged the defendant with forgery, a felony of the degree, 18 PA, CSA Section 4101, 3, firearms not to be carried without a license, a felony of the third degree, 18 PA, CSA Section 6106, 1, tampering with records or identification, a misdemeanor of the first degree, 18 PA, CSA Section 4101, possessing instruments of crime, a misdemeanor of the first degree, 18 PA, CSA Section 907, and false identification to law enforcement, a misdemeanor of the third degree, 18 PA, CSA Section 4914. See Exhibit A. The Commonwealth of Pennsylvania, by and through the Blair County District Attorney's Office, filed a criminal information at CP 07CR 2724-2024 relative to the aforementioned criminal charges. The defense filed an omnibus pre-trial motion and the court scheduled a hearing for November 7th, 2025, at 1:30 p.m. in courtroom number 1 of the Blair County Courthouse, Hollidaysburg, Pennsylvania. The court has been advised by District Attorney Weeks that the defendant is presently confined in the Metropolitan Detention Center, MDC, pursuant to federal charges. The MDC, located at 82 G Street, Brooklyn, New York, 11232, is operated by the Federal Bureau of Prisons, an agency of the United States Department of Justice. The federal authorities confirmed through written notification to the Blair County District Attorney that they will not release or transport the defendant for Blair County, Pennsylvania proceedings, but rather will make the defendant available by two-way simultaneous audio-visual communication for the proceedings in Blair County. The defendant, through his counsel, has advised the court that he does not wish to waive his right to be physically present in the courtroom to litigate his instant pre-trial motions. Therefore, the district attorney and the court are compelled at this point to request the production of the defendant through issuance of a writ. The attendance of the defendant in the Court of Common Pleas of Blair County, Pennsylvania, is for the purpose of pre-trial litigation of the aforesaid charges. The Blair County District Attorney's Office is directed to perfect service of a certified copy of this certification upon the United States Attorney for the Southern District of New York, J. Clayton, or his designee. ITIS therefore requested that the United States Attorney for the Southern District of New York, J. Clayton, cause the defendant to be produced in the Court of Common Pleas of Blair County, Pennsylvania, under custody of the United States Marshals Service, on November 7th, 2025, at 1:30 p.m. and for a period of time necessary to complete pre-trial litigation. By the court, Jackie Atherton Bernard, Judge County of Blair Court of Common Pleas. From Thomas Dickey sent, Tuesday, August 19th, 2025, 10:56 a.m. to Jackie Bernard, Peter Weeks, Nicole Smith. Subject, Luigi Mangione. Dear Judge Bamard, please be advised that after completion of our research into this matter, I have no objection to your Honourable Court executing the writ of habeas corpus ad prosequendum, submitted by the Commonwealth. I thank you for attention to this matter. Most respectfully, Tom Dickey.
But basically, the prosecutors keep pushing things more and more onto Luigi Mangione when his next court appearance is slowly coming up more and more, because this is September the 9th. Again, Luigi Mangione will appear in court on September 16th, and this is September 9th, and you see when his court appearance is slowly approaching, more and more things are being put against him in this case. Again, why do they keep pushing more and more things onto him when he's already dealing with so many more things? It's very frustrating to read. You can probably tell in my voice, I am slowly losing it, but I will get through this. You might just have to deal with me being a little bit more hoarse later in the video. Basically, this document is saying Luigi Mangione isn't rejecting the habeas corpus, he just wants to be there in person when this happens. and that is his right to be. So I'll put the document up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, Defendant No. CP 07CR 2724-2024 Hon Jackie Atherton Bernard Presiding Judge Peter J. Weeks, Esquire District Attorney Nicole Smith, Esquire First Assistant District Attorney Thomas Dickey, Esquire Counsel for Defendant Order of Court, and now, the 8th day of September, 2025, the defendant having filed an omnibus pre-trial motion, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that a hearing on the motion shall be held November 7th, 2025 at 1:30 p.m. in courtroom number 1 of the Blair County Courthouse, Hollidaysburg, Pennsylvania. Contemporaneous with this order, the court is issuing a writ of habeas corpus ad prosequendum for the defendant's in-person appearance. However, in the event that the U.S. Marshal's Office refuses release of the defendant and/or refuses to make the defendant available for transport, the defense shall have 14 days to file of record an objection to or consent to the defendant's remote participation in the aforementioned hearing by the court. Jackie Atherton Bernard, Judge County of Blair Court of Common Pleas CC, Sam Dunkel, Court Administrator Jessica Miller, Deputy Court Administrator Sheriff James Oil, Deputy Chief R.J. Pierre.
This is another document that came out on the same day. Basically, the prosecutor saying, yes, we will send Luigi Mangione to Pennsylvania from New York, and it won't come out of Luigi Mangione's cost. It will be fully paid by them. Honestly, hooray. I'll put it up on screen for you guys.
Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania No. CP 07CR 2724-2024 versus Luigi Nicholas Mangione, Defendant Hon Jackie Atherton Bernard Presiding Judge Peter J. Weeks, Esquire District Attorney Nicole Smith, Esquire First Assistant District Attorney Thomas Dickey, Esquire Counsel for Defendant Order of Court, and now, the 8th day of September, 2025, a petition for writ of habeas corpus ad prosequendum having been presented to this court, upon motion of the Blair County District Attorney without objection by the defendant, see Exhibit A, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that a writ of habeas corpus ad prosequendum issue, requesting that the United States Marshal's Service release the prisoner, Defendant Luigi N. Mangione, MDC Brooklyn Inmate Registration Number 52503-511, to the custody of the Blair County Sheriff's Department and/or other Blair County law enforcement, who shall assume full responsibility for the prisoner's custody and provide for the safekeeping, secure custody, and care of the prisoner at no cost to the federal government, in order to physically produce the body of the prisoner before the Blair County Court of Common Pleas for in-person litigation on the defendant's omnibus pre-trial motion, scheduled for hearing on November 7th, 2025 at 1:30 p.m. in courtroom 1 of the Blair County Courthouse, Hollidaysburg, Pennsylvania. It is ordered that the prisoner shall be returned promptly to the custody of the United States Marshal's Service upon conclusion of the appearance for which the writ was issued, or upon demand of the United States Marshal's Service. This court understands that the United States Marshal's Service reserves the right to deny any request. Furthermore, the Blair County District Attorney is ordered and directed to serve the U.S. Marshal and the United States Attorney with a certified copy of this order, and to perfect service of the writ upon the United States Attorney for the Southern District of New York, by the court, Jackie Atherton Bernard, Judge County of Blair Court of Common Pleas CC, Sam Dunkel, Court Administrator Jessica Miller, Deputy Court Administrator Sheriff James Oil, Deputy Chief R.J. Pierre. From Thomas Dickey sent, Tuesday, August 19th, 2025 10:56 a.m. to Jackie Bernard, Peter Weeks, Nicole Smith. Subject, Luigi Mangione. Dear Judge Barnard, please be advised that after completion of our research into this matter, I have no objection to you, Honourable Court, executing the writ of habeas corpus ad prosequendum, submitted by the Commonwealth. I thank you for attention to this matter. Most respectfully, Tom Dickey.
Miss Dickey and Luigi Mangione have been fighting about this for such a long time. I'm glad this is actually happening. He does have the right to be there in person. And literally the prosecutors have been like pulling teeth. the prosecutors through this entire thing. From like, literally, we've seen it with like Luigi Mangione's lawyers in New York. We've seen it with Luigi Mangione's lawyers in Pennsylvania. The prosecutors have been like, what the prosecutors are doing are like pulling teeth slowly and painfully and being difficult. Also, I'm quite surprised the cat hasn't come in and like started chatting to me. She normally does that in this point in the day, but I think she's sleeping. But she did give me comfort when I was watching the live stream last night. 11th of September 2025. This is a interview with Thomas Dickey of him explaining Luigi Mangione does have the right to appear in person in Pennsylvania, and this is a interview with Thomas Dickey. Hi, it's VoiceOver Me. So I couldn't find the full interview with Thomas Dickey anywhere, but if you guys can find it, please send it to me. I'll love to watch it and I'll bring it up in my next video talking about Luigi Mangione. But yeah, I could only find this 19-second clip of the interview, but I think it tells enough about the information we need to know. Anyway, bye guys. So I'll put the little clip up for you guys.
The best interest of Mr. Mangione is to move forward with these hearings without having him here. Then that's what we'll do. However, but yeah, you know, we want him here because it is a constitutional right to be here, and we just don't give up constitutional rights, you know, at a whim.
So that was the interview with Thomas Dickey, him saying Luigi Mangione does have the right to appear in person in Pennsylvania because that is his right to do so, and it very much is. Do you guys get pins and needles in your legs when you sit on the floor for too long, or is it just a me thing? Do I have a problem with my back? Am I getting old? I guess so, I'm 24. The 16th of September 2025. This is the big day when Luigi Mangione had his court appearance, and this is the most current information we have about it. I only have about 3 things about this entire thing. Again, we'll probably see more stuff come out in the next couple of weeks. Again, I am filming this on the 17th, so again, we'll probably see more information about this later on. And I showed you guys all the photos and stuff and videos of Luigi Mangione at the beginning of this video. So I'll show you all the documents first and then like my little thoughts afterwards, because a lot of these notes I was writing literally when it was happening. So I'll put that at the end after I show you all the documents we currently have. Yeah. So this is the transcript from the courtroom. I'll put it up on screen for you guys.
MS Friedman Agnifilo, Karen Friedman Agnifilo, Mark Agnifilo, and Jacob Kaplan, on behalf of Luigi Mangione. Good morning, the court. All right. Good morning, everyone. You all should have gotten an electric copy of the decision. So just to summarize, I want to say that I carefully looked over your submissions, the defense motions, the people's response to those motions. I carefully reviewed the grand jury minutes, the evidence that was presented before the grand jury, as to counts 1 and 2, charging the defendant with murder in the first degree, and murder in the second degree, under the terrorism statute. The evidence put forth before the grand jury was legally insufficient for those charges. Therefore, those 2 charges are dismissed. As to the remainder counts, the evidence before the grand jury was legally sufficient and they remain, including murder in the second degree, intentional. As to the defendant's motion to dismiss under double jeopardy grounds, that's premature. The defendant has not been tried in any other jurisdiction under similar alleged facts, and I'm not persuaded by the defendant's motion to stay this prosecution, so that is denied. As to hearings that were requested, the people consented to all hearings, a Huntley hearing, a map hearing, and should the people put on a non-eyewitness, identifying witness, a Mosley hearing would be held. That's the decision of the court. So I'd like to discuss scheduling, if you can come on up for that. Proceeding continues. The court, okay. Any objection to that certificate of compliance needs to be, obviously, You'll talk to the people, see if you can rectify anything you believe is missing, and file any motion within 30 days. Okay. Ms. Friedman Agnifilo, thank you. The court, all right. Come on up. Discussion at the bench. The court, all right. We had a discussion at the bench about scheduling the hearings, and I believe all sides agree that on the 1st of December we will start the hearings in this case. Counsel, do you want to be heard? Ms. Friedman Agnifilo, yes, Your Honor. We have an open motion to the court regarding the Aetna subpoena. The court, yes. I'm making no judgments about the legality of the subpoena. However, the people will be precluded from using anything received under that subpoena. Ms. Friedman Agnifilo, thank you, Your Honor. And, Your Honor, at the bench we discussed this issue of 250.10 notice, and we respectfully would like an opportunity to file a motion with the court, which we intend to do in the next 2 weeks. The court, well, the next 2 weeks, you don't have much time. Ms. Friedman Agnifilo, we understand. The court, so get it as soon as possible, actually. Ms. Friedman Agnifilo, okay. And one last thing, Your Honor, we would like an opportunity to view the property that will be the subject of the map hearing from the district attorney. The court, okay. You can work that out. Proceeding continues.
So basically the hearings will start on December 1st, 2025, so that is finalized. And also another thing that was brought up in this transcript where you saw early in the video and a couple of videos ago, the massive HIPAA violation by the prosecutors, that will not be used whatsoever in this case. So that was brought up in the transcript. So now we are going to be moving on to the next document. This is the document from Judge Requiro. I think that's how you say it. I probably fucked up. Sorry, guy. Sorry. But this is basically the document he wrote. But I do want to add this here before I show you guys the document. Basically, in this document, it does not use the word alleged, so please be prepared when things are mentioned in this video. I was not prepared. When I read this document this morning, when I woke up, it's like, I was not prepared for that. So I just want to put that there. So anyway, I'm going to put the document up on screen for you guys.
Supreme Court of the State of New York, New York County, Part 32. The people of the State of New York, against Luigi Mangione, defendant. Decision and order in 75-657, 24 ex-Justice Gregory Caro, on December 4, 2024, Brian Thompson, the CEO of United Healthcare, was shot to death outside of the Hilton Hotel in Midtown Manhattan. Video surveillance captured a man wearing a mask, dressed in black and carrying a backpack, drawing a gun and shooting Thompson in the back and the leg. Video also established that below the shooting, the man drank from a water bottle and threw it in a nearby trash can, that he dropped a cell phone as he fled the scene, and that he discarded the backpack in Central Park. Investigators recovered ballistics evidence from the scene, including 3 shell casings, on which depose, delay, and NR had been written. Investigators were able to trace the shooter's movements to a hostel in Upper Manhattan, where he had registered using the name and identification of Mark Rosario, and they also found evidence that he took a train to Philadelphia following the murder. On December 9, 2024, the defendant was arrested at a McDonald's in Altoona, Pennsylvania, after he was recognized by employees who had seen media coverage. A 9mm gun was recovered from the defendant's backpack, as well as ammunition, a silencer, a fake New Jersey driver's license in the name of Mark Rosario, cash, a passport, and a notebook in which the defendant had made journal entries. There were also 2 letters in the backpack, one addressed to his family and one to the FBI. Ballistics analysis demonstrated that the shell casings recovered at the scene were fired by the gun found in the defendant's backpack. DNA analysis also established that defendant's DNA was on the water bottle found at the scene and on the eye likely intended to read deny. Video surveillance footage showed the man without a mask, both at the hostel and at locations before the shooting occurred. Photos of suspects circulated on national media. Backpack discarded by the shooter. Defendant's fingerprints were also found on the water bottle and on a kind bar wrapper found near the scene. Defendant was indicted TBR murder in the first degree, PL $125.27, I, 13, victim killed in furtherance of an act of terrorism, as defined in PL $490.05, murder in the second degree as a crime of terrorism, PL $125.25, 1, 490.25, murder in the second degree, PL gram 125.25, 1, intentional. 2 counts of criminal possession of a weapon in the second degree, PL 265 Singapore dollars and 3 cents, LB 265.033, criminal possession of a weapon in the third degree, PLQ 265.027, 2 counts of criminal possession of a weapon in the third degree, PL $265.02, 8, criminal possession of a weapon in the third degree, PL $265.02, 2, criminal possession of a weapon in the fourth degree, PL $265.01, 9, and criminal possession of a forged instrument in the second degree, PL $L70.25. Defendant has filed an omnibus motion, seeking Huntley, Mapp and Mosley here NGS. The defendant also moves to dismiss the terrorism charges as legally insufficient, moves to dismiss the entire indictment for alleged violations of the Double Jeopardy Clause, and argues that the state case should be stayed pending resolution of a concurrent federal case. 3. The people have filed a response consenting to pre-trial hearings and opposing the motions to dismiss and to stay the proceedings. The defendant has additionally filed a reply to the people's response, and the people have filed a surreply. The court has reviewed all submissions and decides as follows. Suppression hearings. Huntley, Mapp and Mosley hearings are ordered. Motions to dismiss. Defendant's motion to inspect the grand jury minutes for legal sufficiency pursuant to CPLS 210.30.2 is granted. The standard of review for legal sufficiency is whether there is competent evidence which, if accepted as true, would establish every element of an offence charged and the defendant's commission thereof. CPL $70.10. L. Legally sufficient evidence means a prima facie case, not proof beyond a reasonable doubt. People VSV, Amp, 84 NY2D 725, 730, 1995. A court must consider whether the evidence viewed in the light most favorable to our defendant was indicted in the Southern District of New York for murder, stalking, and firearms charges based upon the same incident. The federal prosecutors have filed a notice of intent to seek the death penalty. The people if unexplained and uncontradicted, would warrant conviction by a petite jury. People v. Bello, 92 NY2D 523,525-26, 1998, quoting People v. Jennings, 69 NY2D 103, 114, 1986. Penal law provisions are generally to be construed so as to give effect to their natural and obvious meaning, particularly where the definition of a crime is at issue, because courts must be scrupulous in ensuring that penal responsibility is not extended beyond the fair scope of the statutory mandate. People v. Hegeman, T0NY2D 533,537, 1987, quoting People v. Wood, 8 NY2D 48, SL, 1960. Here, defendant argues that there is legally insufficient evidence of first-degree murder, alleging that the victim was killed in furtherance of an act of terrorism, and of second-degree murder as a crime of terrorism, and urges that the court dismiss those 2 counts of the indictment. Defendant argues that both legislative intent and case law demonstrate that defendant's actions do not fit within the statute, and that the people did not present legally sufficient evidence of those counts. The people argue that both counts are legally sufficient, and that terroristic intent was established because the defendant was not engaged in a personal vendetta, but violently broadcast a social and political message that inspired threats to employees or UHC. New York's terrorism statute, set forth in Article 490 of the Penal Law, was enacted on September 17, 2001, just 6 days after the September II attacks. The legislature was able to act so quickly because it liberally borrowed from already existing federal legislation. See Greenberg and Urowitz, Analyzing New York's Anti-Terrorism STDT 10, NYLJ, May 13, 2002. See also People vs. Morales, 20 NY 3D 240,248, 2012. Definitional provisions of statute drawn from federal legislation. Legislature was able to act quickly because of the model provided by existing federal anti-terrorism legislation. Quoting Greenberg et al., New York Criminal LCRW $39. 1. The legislative findings state that the devastating consequences of the recent barbaric attack on the World Trade Center and the Pentagon establish a compelling need for legislation designed to combat the evils of terrorism. PL $490. The examples of terrorism cited in the legislative findings are L. September 11, 2001 attacks. 2. The bombings all American embassies in Kenya and Tanzania in 1998. 3. The destruction of the Oklahoma City federal office building in 1995. 4. The mid-air bombing of Pan Am Flight No. 103 in Lockerbie, Scotland in 1988. 5. The 1997 shooting from atop the Empire State Building. 6. The 1994 murder of Ari Halberstam on the Brooklyn Bridge. And 7. The bombing of the World Trade Center in 1993. PL $490. Under PL 125.27, 1. A person commits first-degree murder when, with intent to cause the death of another person, he causes the death of such person, and the victim was killed in furtherance of an act of terrorism, as defined in PL $490.05. 1. B. Under Article 490.05, B. A person is guilty of first-degree murder when they engage in activities that involve a violent act or acts dangerous to human life, that are intended to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, or reflect the conduct of a unit of government by murder, assassination or kidnapping. Similarly, a person is guilty of second-degree murder as an act of terrorism when he commits a specified offense, including second-degree murder under PL $125.25. 1. That is intended to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination or kidnapping. PLG 90.05. 1. The people assert that they have established all three intents, although they focus on intimidate, ein, or coerc, ein, a civilian population, yet they also briefly argue that defendant intended to influence or reflect the policy of a unit of government by intimidation or coercion through his actions. There was insufficient evidence presented in the grand jury to support this claim. There was no evidence presented that defendant made any demands of government or sought any particular governmental policy change, let alone that he did so by intimidation or coercion. See People vs. Parker, 231 NYS 3D 276,282-83, 3D Dep 2025. Hat, the defendant was motivated by animus toward law enforcement, did not establish an attempt to influence any government policy through his actions. Defendant's statement about need for change in solution to establish an attempt to influence a policy as opposed to expressing anger. C/People v. Jenner, 39 AD 3D 1083, 1086. 3D Dep 2007, evidence established that defendant specifically intended to influence Department of Social Services policy. Indeed, as the federal authorities noted, the defendant's goal appeared to be to draw the public's attention to what they also assert that the defendant's terroristic intent can be inferred from the defendant's acts alone. Given the specific language and requirements of the statute, the CAUFI is unpersuaded that is the case. Perceived to be problems with the healthcare industry. 5. The people place great emphasis on one snatched phrase, revolutionary anarchism, in defendants' writings to suggest that this satisfies the statutory element of an intent to influence the policy of a unit of government by intimidation or coercion, or affect the conduct of a unit of government by murder, assassination or kidnapping. 6. Not only does this stretch the import of a two-word phrase beyond what it can carry, but it ignores other, more explicit excerpts from defendant's writings in which he states that his goal is to spread a message and win public support about every thing wrong with our health system. Therefore, the court finds that the people failed to establish an intent to influence or affect government. This court will focus on the intent element that both sides appear to emphasize, the intimidation or coercion of a civilian population. The court will note that the term terrorism has been more difficult to define. 7. Our Court of Appeals has cautioned against expanding the definition of terrorism beyond what the legislature intended. The concept of terrorism has a unique meaning, and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. More or less, 20NY3D at 249, the legislature incorporated a general definition of the crime, and referenced 7 notorious acts of terrorism that serve as guideposts for determining whether a future incident qualifies for this nefarious designation. LD. As noted above, those notorious acts include the massive death and destruction of September 11th, the 1998 bombings of American embassies, the 1995 destruction of the Federal 5C U.S. Attorney's Office, Southern District of New York. Press release, December 19, 2024, Luigi Mangione charged with the stalking and murder of United Healthcare CEO Brian Thompson and used OJ as silencer in a crime of violence. 6L in his notebook. Defendant compared himself to Ted Kaczynski, the Unabomber, stating that Kaczynski had indiscriminately mail-bombed innocents, thus crossing the line from revolutionary anarchist to terrorist, the worst thing a person can be. The people's suggestion that this single sentence established that the defendant intended to influence governmental policy or affect the conduct of a unit of government is not persuasive, says Exhibit A, People's Affirmation and Response. The search FBR definition of terrorism has been compared to the quest for the Holy Grail. See Perry, The Numerous Federal Legal Definitions of Terrorism, The Problem of Too Many Grails, 30 Jules Legis 249, 2004, Levitt, Is Terrorism L. Auth Deafening, L3 Ohio NUL Retherland 97, 1986. Some resort to Justice Stewart's comment on obscenity, I'll know it when I see it. See Perry, 30 Jules Legis at 250 N, 8. Office building in Oklahoma, and the bombing of Pan Am Flight 103 in 1988. PL Gram 490.00. C. Parker, 23 LNYS 3D at 282 N, 2. The inclusion of these distinct acts of terrorism underscore the legislature's understanding of the egregious nature of the conduct that constitutes terrorism. In Morales, the defendant was a street gang member operating in a particular area of the Bronx. At a christening party, the defendant fired 5 shots at one of his rivals, who was paralyzed. The shots also killed a 0-year-old Jeb. The prosecution argued that there was sufficient evidence of terrorism because the defendant intended to intimidate or coerce other Mexican-American gangs, and by inference, all Mexican-Americans in the geographical area. The appellate division dismissed the terrorism convictions, finding that there was no intent shown to intimidate or coerce the Mexican-American population residing in that particular area of the Bronx. People v. Morales, S6AD3D 147, 154, I St. Dep 211. The court also found that members of other Mexican-American gangs in that area of the Bronx did not qualify as a civilian population under the statute, finding that the context of the statute weighed against stretching the meaning of the language to cover such a narrowly defined subcategory of individuals. LD at 156. Examining the legislative findings and the examples of terrorism listed, it was clear that the legislature intended to address extraordinary criminal acts perpetrated for the purpose of intimidating a broad range of people, not a narrowly defined group of particular individuals. 1D, the court noted that it was not minimizing the heinous nature of the criminal conduct or the stark tragedy of its consequences, but the conduct did not fall within the definition of terrorism. ID, at 16 liters. The Court of Appeals affirmed the appellate division's dismissal of the terrorism convictions and ordered a new trial on the remaining counts. The court noted that the statute did not define the phrase intent to intimidate or coerce a civilian population, but stated that it should be given its most natural and obvious meaning, based on common sense and reasonableness in the context of the purpose and history of terrorism statutes. ID, at 247, civilian population could be read broadly to encompass a variety of communities depending on how area is defined and who lives within that territory. 8. The court found it unnecessary to precisely define the term civilian population, but it concluded that even if all Mexican Americans living in a particular area could be considered a civilian population, the evidence did not demonstrate that the defendant committed his discrete act with the conscious objective of intimidating every Mexican American in the territory, identified al real, ID. Moreover, the court found that there was no indication that the legislature enacted Article 490R, the intent to elevate gang-on-gang street violence to the status of terrorism as that concept is commonly understood, D. at 248. The statute cannot be interpreted so broadly so as to cover individuals or groups who are not normally viewed as terrorists. 1D. The court further stated that the legislature clearly did not intend to extend the reach of the statute to this type of crime, and this was apparent by looking to the examples of terrorism cited in the statute. The crimes committed by the defendant obviously were not comparable to those terroristic acts. ID. As in Morales, the question presented here is whether defendant's act, no matter how heinous, fits within the definition of terrorism as set forth in the statute and is illuminated by legislative intent. This CAF does not believe that the legislature intended the employees of a company, however large, to constitute a civilian population within the meaning of the statute, giving the phrase its natural and obvious meaning, based on common sense and reasonableness. It is clear that the term encompasses inhabitants of a particular area, or at least a group of inhabitants of a particular race or class living in a particular area. See Morales, 20 NY3D at 247. Term can encompass a variety of communities depending on how area is defined and who/IBS within that territory. Emphasis added. See also Morales, 86A D3D at 156-57. The term and legislative history of statute implies an intention to create a pervasively terrorizing effect on people living in a given area, cannot stretch meaning of statute to cover a narrowly defined subcategory of individuals. Muhammad v. Commonwealth 269 YA 451, 499, 2005. Population at large requires a more pervasive intimidation of the community rather than a 3. The court noted the dictionary definition of population as the total number of inhabitants constituting a particular race, class, or group in a specified area, or a particular section, group or type of people living in an area or country, or a body of persons having some quality or characteristic in common and usually thought of as occupying a particular area. LD at 24 feet 7 NL. Narrowly defined group of people. Moreover, as in Morales, even if this court were to find the employees of one company to constitute a civilian population, there was no evidence presented that defendant's conscious objectite or intent was to intimidate or coerce the employees of United Healthcare. The people point to defendant's journal entries found in his backpack as evidence of terroristic intent, but those writings ultimately do not aid the people's argument. The defendant's apparent objective, as stated in his writings, was not to threaten, intimidate, or coerce, but rather to draw attention to what he perceived as the greed of the insurance industry. Members of the public can focus on greed and, as an additional possible consequence, to negatively affect the financials of the company. The defendant emphasized that he wished to spread a message and win public support about everything wrong with our health system. The defendant explicitly contrasted himself with Ted Kaczynski, the Unabomber, because he indiscriminately mail-bomb, ed, innocence, and cross, ed, the line, to terrorist, the worst thing a person can be. Exhibit A to people's affirmation in response to defendant's omnibus motion. While defendant's own characterization of his conduct is of course not dispositive, where there is no other evidence of terroristic intent, the writings failed to supply that evidence, Contrary to the people's characterization, the people presented sufficient evidence that the defendant murdered Brian Thompson in a premeditated and calculated execution. That does not mean, however, that the defendant did so with terroristic intent. Notably, the federal authorities, while recognizing that Brian Thompson was gunned down in cold blood, did not charge the defendant with crimes of terror, but with using a firearm to commit murder and related crimes. Even though the federal terrorism statute served as a model TBR the state statute regarding defendant's intent, the acting United States Attorney for the Southern District stated that defendant's goal was a grossly misguided attempt to broadcast his views across the country. The Assistant Director of the FBI stated that the defendant committed murder to incite national debates and that he deemed murder an appropriate recourse to satiate U.N.C. Huey Miko. In CEO Murder Q.O. Test of New York's anti-terrorism laws, NY Times, December 26, 2024, et al. Former appellate judge James M. McCoy quoted as stating that it was difficult to conclude that the legislature intended civilian population to encompass persons working for health insurers who make coverage decisions. Personal grievances, and E.U.S. Attorney's Office, Southern District of New York. Press release, December 19, 2024, Luigi Mangione charged with the stalking and murder of United Healthcare CEO Brian Thompson and use of a silencer in a crime of violence. The people suggest that the element of intimidation and coercion can be met because some UHC employees felt fearful after the murder, and some UHC employees received threats. But putting aside that some employees received threats even before the murder, one so serious that investigators traveled to another state to investigate, and every murder has the potential to induce some degree of fear. For example, a random murder in the subway will cause riders to feel fearful about riding the subway, that ails to establish that this was the defendant's intent, or that the conduct fits within the statutory definition of terrorism. Using the guideposts of 7 examples, as directed by Morales, 20 NY3D at 249, defendant's crime as in Morcles, is similarly not comparable to the examples listed in the statute. There was no evidence presented of a desire to terrorize the public, inspire widespread fear, engage in a broader campaign of violence, or to conspire with organized terrorist groups. Here, the crime, the heinous, but targeted and discreet killing of own person, is very different from the examples of terrorism set forth in the statute. The examples cited in the statute share the characteristic of indiscriminate killing which produce one ear and terror, whether car bombing, or through the indiscriminate shooting of multiple victims. The indiscriminate nature of the shooting or bombing strikes terror into the population and induces a fear not to engage in daily activities for fear of violence. As the legislative findings note, terrorism disrupts public order and threatens individual safety. PL $490. The concept of terrorism has a unique meaning that risk is being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. More or less, 20 NY3D at 249. This court need not reach the issue of whether the statute encompasses an act that only involves a single victim, but the court will note that the people's reliance on 2 of the examples set forth in the statute, the Empire State shooting and the Ari Halberstam killing on the Brooklyn Bridge, as incidents that encompassed only one victim, is misplaced. Those incidents were very different than those presented here. In the 1997 shooting at the Empire State Building, the gunman, who expressed his desire for revenge for the treatment of Palestinians, opened fire with a semi-automatic weapon on the observation deck, killing 1 person and wounding 6 others. R0 in the 1994 Ari Halberstam shooting, the gunman, motivated by a desire to retaliate against Jews, fired shot after shot into a van of Orthodox Jewish students, killing 1 and injuring 3 others. The defendant's targeted killing of an individual, although abhorrent and despicable, is not comparable. R2C Morales, 20 NY3D at 248. While there is no doubt that the crime at issue here is not ordinary street crime, it does not follow that all non-street crimes were meant to be included within the reach of the terrorism statute. While the people place great emphasis on defendant's ideological motive, there is no indication in the statute that a murder committed for ideological reasons. In this case, the defendant's apparent desire to draw attention to what he perceived as inequities or greed within the American healthcare system fits within the definition of terrorism, without establishing the necessary element of an intent to intimidate or coerce. The court agrees with the defendant that the people appear to conflate an ideological belief with the intent to intimidate or coerce a civilian population. While the defendant was clearly expressing an animus toward UHC and the healthcare industry generally, it does not follow that his goal was to intimidate and coerce a civilian population, and indeed, there was no evidence presented of such a goal. As the Third Department recently held, we look to the acts of violence in this case within the guideposts of the specific acts of terrorism referenced in the statute, and through that lens, the court declined to loosely interpret the defendant's conduct in the case as fitting within the statute. Parker, 23 LNYS 3D at 283. As in Parker, I do not sanction the defendant's heinous conduct, but it does not compo with our current understanding of terrorism. LD, see also more or less. 20 NY 3D at 249. Here, the evidence presented failed to establish that the defendant committed the crime to coerce or intimidate a civilian population, or to influence or affect the policy of a unit of government, and therefore, the first two counts of the indictment are dismissed. The remaining are 0C Matthew Purdy, N. Pice Lock Orndon's note, Kill Zionists, NY Times, February 26, 1997, at A. RRC Shayla Duan, L.5, decides 91 at Con Hasidim was Loan Act, NY Times, December 6, 2000, at 89. Note that the prosecutor for Grand Traverse County, Michigan, chose to indict a defendant who stabbed II people at a Walmart for terrorism because his intent was to bring fear and destruction to a community as a whole, rather than to harm specific individuals. Manf says terrorism charge in Moss stabbing at a Michigan Lamet, NY Times, July 27, 2025. Counts of the indictment, including murder in the second degree, are legally sufficient. Defendants claim double jeopardy, violation and request for a stay. Defendant argues that concurrent state and federal prosecutions violate the double jeopardy clause of the United States Constitution and CPL $40.20. Barring prosecution for two offenses based upon the same act or criminal transaction. However, as the United States Supreme Court has held, where there are two sovereigns, there are two laws and two offenses. Gamble versus United States, 587 U.S. 678,683, 2019. A crime against two sovereigns constitutes two offenses because each sovereign has an interest to vindicate. ID, at 687. Thus, there is no double jeopardy violation. While it is true that CPL $40.20 grants greater protection than that of the state or federal constitution, that bar is triggered only when a prior prosecution ends in a conviction by guilty plea, or once a jury has been sworn. CPLS 40.301. Therefore, because neither event has occurred, defendant's motion is premature. Defendant nonetheless argues that he is prejudiced by concurrent proceedings, because he will be forced to litigate a federal case in which he faces the death penalty while the state case is proceeding to trial, and that testifying in the state case may prejudice him during his federal trial, thus implicating his rights to defend himself and against self-incrimination. Defendant suggests that the federal case should proceed first, even though the federal and state authorities have agreed that the state case should proceed to trial first. This court is not persuaded that proceeding to trial in the state case first will cause the defendant severe prejudice, and the defendant's claim that any state trial testimony will prejudice his federal trial is merely speculative. See Curia y Virginia, 585 U.S. 493, 503, 2018. Moreover, defendant cites to no case law or authority that would permit such a protracted adjournment, as even defendant concedes that the federal case will take several years before trial. The court is also confident that counsel will have the capability to manage an approximately 2-month state trial during the pendency of the several years before the federal case proceeds to trial. Defendant's request to stay the state proceedings is denied. Summary counts 1 and 2, charging defendant with murder in the first degree, in furtherance of an act of terrorism, and murder in the second degree as a crime of terrorism, are dismissed as legally insufficient. The people presented legally sufficient evidence of all other counts, including murder in the second degree, intentional. Thus, the motion to dismiss is denied in all other respects, as is the motion to stay the proceedings. This constitutes the decision and order of the court, dated September 16, 2025.
In this document, it does explain a little bit more of what was allegedly found in his backpack. I did find that interesting. And also in this document, it explains basically the terrorist charges will be dropped because, again, they don't have any official evidence to pin the terrorist charges against Luigi Mangione, so that charge has been thrown out, and also all the alleged evidence they found on Luigi Mangione has been thrown out legally. And that's very true. Literally, I think it was like 7 or 8 hours his backpack was searched multiple times without a search warrant, and then anything could have happened in that time, so I'm very glad that happened. So when I heard about the terrorist charge being dropped, it was like roughly around 1 a.m. I was still very anxious to go to sleep, and I saw it, and then I immediately squealed when I first heard about that. I know I should have not had that reaction when I heard that news. Holy shit, that's fucking amazing. And also same thing with the evidence being thrown out. I only heard about that today, not like last night, but that's insanely exciting stuff for Luigi Mangione and his legal team. And I do really hope in the future, in his next court appearances, a lot of the other charges against him, like the death penalty and the other charges put against him, will be thrown out. That is wishful thinking. Also, I found this interesting when I was reading the document. They brought up a FBI agent, and I was thinking, like, is that like the FBI agent that's known to do sketchy shit, like, allegedly? I don't know, I just found that interesting. They brought him up about the evidence and all that. It's like, oh yeah, he has evidence and he brought it up. And I found that interesting. It's like, is that the one who's like very good at like corrupting evidence and all that? Anyway, allegedly something to chew on. Please don't sue me. So this is another document that also came out on the 16th of September. This is basically a motion to request more time, and I'll put it up on screen for you guys.
September 16, 2025 by ECF, the Honorable Margaret M. Garnett, U.S. District Judge, Southern District of New York, 40 Foley Square, New York, NY 10007 Re, United States v. Mangione, 25 CR 176, MMG. Dear Judge Garnett, the current schedule in the above referenced matter for pre-trial motions, not related to the constitutionality of the death penalty 1, is as follows. Defense motions due September 26, 2025, government's response due October 31st, 2025, and defense's reply due November 14, 2025. The defense respectfully requests the following modest adjustment to these deadlines. Defense motions due October 10, 2025, the government's response due November 14, 2025, and the defense's reply due November 21st, 2025. The government does not object to this request. Importantly, this request is made with the shared understanding that December 5th, 2025, pre-trial conference remains firmly in place. The parties agree that maintaining that date is a priority, and we do not seek any adjournment of the conference, notwithstanding the proposed adjustments to the motion schedule. Thank you for your consideration. Respectfully submitted, Karen Friedman Agnifilo, Mark Agnifilo, Jacob Kaplan CC, Gut Counsel, via ECF, Moskowitz, Colson, Ginsburg and Schulman, via ECF, wonders per this court June 16th, 2025, order. The defense will be filing its death penalty motions this Friday, September 19th, 2025.
Okay, so I do have a couple of notes of what Luigi Mangione looked like when I was watching the live stream. Again, I did screen record the video when Luigi Mangione walked into court, and I do want to say a couple of things. He does look a lot healthier than we saw a couple of months ago when we saw him in court, and I think back then he probably was not eating properly. He did look a lot thinner than he is now, so that is really nice to see. But he does look like a man who's been in a place for such a long time and dealt with so much shit and stress and everything. He does look like that, and it is really sad, and I'm glad he does have his chin up through every single court appearance. He does have his chin up in those videos, and he does look scared, honestly, but I think you need to keep having a brave face when dealing with this entire fucking thing. But I am glad he does look a little bit more healthier than we saw back in the beginning of the year, where he probably was not eating correctly. And I'm quite surprised, like, this is my first thought when I first saw him. I'm surprised he wasn't in court approval clothing like Karen Agnifilo requested. It does very much look like he was in a prison uniform like we saw in the sketches in his last court appearance. I think there's also like a photo a couple of months ago of like him outside of the courtroom in a bulletproof vest in something similar, so it looks like he is in something like that. Again, I am quite surprised court approval clothing like Karen Agnifilo requested. Hopefully in his next court appearances he will be. Also, his hair's a lot shorter. Yeah, I found that interesting. It's like, oh, I'm not used to that. I'm just used to him having long hair. I think he just likes his hair that way, I think. I don't freaking know, I'm not him. Hi, it's voiceover me. So I really want to talk about this. So I literally saw this on like when I finished to sit down to edit this video, when I finished filming on the 17th, and then all more photos were coming out of Luigi Mangione. I noticed that night when I was like downloading photos for this, is in one of the photos there is clearly a picture of Luigi Mangione sitting at one of the tables in the courtroom writing down notes. He is still handcuffed, and the handcuffs are still very much attached to the belt he is wearing, and you can very much see there are bruising on his hand, and I don't know if the bruising is from the handcuffs digging into his hands or from something else, but that is still very alarming. And we've seen before in the past where Luigi Mangione in court, when he's allowed to write things down, and he's unhandcuffed for that, and he's allowed to write notes that way. And I don't understand why in hell they did not unhandcuff him to let him write notes, and very much still have it attached to the belt he is wearing, that I might add, for the handcuffs to be attached to. We've seen that before in like other photos of him appearing in court. So I don't know why they're doing that. Is that like another way for them to degrade him, to not handcuff him, to have him still very much be attached to the belt so he can't write notes? Anyway, I haven't seen many people talk about this, and I really wanted to bring this up because of the bruising we can see on his hands, and I find it very alarming, and I wanted to talk about this. Again, I'm going to actually look at all the photos and more footage more thoroughly for the next video on Luigi Mangione. Again, I just wanted to get this video out and recorded as soon as possible, so I will have time to look over everything more thoroughly, like the photos and videos and all that, but I did really want to bring this up in this video. I just find it very alarming there is bruising on his hands. Another thing I do want to bring up in like some photos of him, again, I did not look at all the photos when they were coming out. I only noticed this when I was downloading them for this video. You can see Luigi Mangione has very heavy bags under his eyes, like they're like purple with like a little bit of yellow, but I think the yellow is the lighting, but I just do want to bring that up as well. He does have very dark bags underneath his eyes that are also could be something to be alarmed about. So it looks like he is not sleeping well. My opinion about that anyway. Anyway, I just thought I should bring those two things up that I think they should be noted, and everyone should know about that. That is all the current information we have about the Luigi Mangione case. As me filming this video, the 17th of September 2025, there's definitely going to be more things popping up in the next couple of weeks about this case, and again, I will always keep talking about Luigi Mangione and all that. And now we are going to be moving on to my final thoughts about the entire case, some things that weren't really relevant, but I do want to add in this video. I have a big chunk for this. Get ready for me to yap on for 25 minutes. I guess you guys are used to that, you watch these videos. So I do want to add this here. So some of these notes are literally from a couple, like earlier this month, and then some of these are more recent, like from last night when it was 1 a.m. and I needed to go to sleep. Is that a bug? What the fuck? Get out of here. Get. You can't be a part of this video. So, over the last month or so, I have felt insanely anxious, scared for Luigi Mangione. I felt it in my soul, and weird feeling to have, being so afraid for someone, you feel it in your soul. And I mentioned that on Reddit in a comment section or whatever, and someone agreed. You're yeah, they also felt that way, and I can't imagine what his friends and family and Luigi himself feel like when we feel like this for his court appearances, and then could he be feeling, or what his family will be feeling going through this entire thing. I can't imagine. And like I said before, he did look really scared and tired, and he's been through so much shit when we saw him last night. But yeah, I can't imagine what he would be going through, dealing with all this. I know I shouldn't have that feeling when I feel so scared for someone in my soul towards a stranger, but I do, and I can't help it, and I really shouldn't. But yeah, that fear in my soul for him. And I know Luigi Mangione, he does have back problems, and I really don't want him to be in too much pain, because I'm pretty sure those beds or anything they do in jail would be very good for his spine, and I don't want him to be in too much pain. So I do want to bring this up. This is more so about the censorship of Luigi Mangione's name. I mentioned this in my last video about Luigi Mangione and the censorship of what's happening with Luigi Mangione's name, and it's happening again. It's happened to me a couple of times, and it's happened to me on different platforms like Instagram, YouTube, and now it's happened to me again on TikTok, where I'm trying to share accurate information talking about Luigi Mangione and what's actually happening with his case. And I do use wording where my videos won't be taken down in the comment section, or little shorts, reels of videos, etc. But the censorship stuff is getting insane. I had 2 posts on TikTok taken down, literally just sharing accurate information with Luigi Mangione's case. And this is more recent information. One of the posts I had up on there was literally me showing all the things Luigi Mangione has to deal with this month, and the next post was literally about the updated URL. Those 2 posts got taken down for violating guidelines when they did not whatsoever. I didn't say Luigi, I did not say Luigi Mangione, and it's getting annoying and frustrating. And the reason why I bring this up is, you guys probably saw my community post about it, but I do want to keep bringing it up. The amount of times things have been censored because of Luigi Mangione and his case and all that. We do need to keep talking about Luigi Mangione, and we do need to keep the accurate factual information about his case out there compared to letting the media take control and telling us what we should think about him in reality when that's not the case. And you guys probably saw my community tab about it. I did post it around everywhere, and I do want to keep talking about it every single time when one of my posts get taken down, because again, I'm just sharing accurate information about Luigi Mangione and his case. Again, I did dispute those with TikTok. The post did get back up, and yeah, the censorship with Luigi Mangione's name is getting insane. We need to keep talking about him. We need to keep talking about the accurate information about Luigi Mangione's case and keep putting it everywhere, because again, it's happened to me a couple of times now. I think 5 at this point of my videos being taken down on different platforms for talking about accurate information about Luigi Mangione. I don't care about views or whatever. I just want more people to know about the accurate information about him and his case compared to, like, say, the media. So I've noticed this, and a couple of other people have noticed this as well on Reddit, where a lot of the Reddit community groups have slowly died down talking about Luigi Mangione and his case. And someone did mention it's literally because of the lack of photos of Luigi Mangione, and I do sadly agree. There are a lot of people out there that are only following this case because they think Luigi Mangione is cute or attractive, or they think he's hot, and that's really it. And that is a very shallow way to go about this entire case. And I do find that really sad, where people are more focused on Luigi Mangione's appearance and what he looks like more than this actual case itself. And yes, he is a good-looking man, but he is more than just a piece of meat to look at and stare at and make fan fiction and edits and all that. He is a real human being with thoughts, feelings, and he's going through so much right now, and we need to care more about Luigi Mangione the person than Luigi Mangione the person we look at that we think is attractive. And it is kind of sad people are only following this case because they think he is attractive, and that's sad, I think, anyway. So we need to keep talking about Luigi Mangione and his case more than he is just a very attractive man. So I want to add this here. So when I released the footage of that short clip of Luigi Mangione walking into the courtroom that I screen recorded and posted everywhere for, like, everyone to use, you can do whatever you want with it, I don't mind. Please don't report it though. And I got a lot of comments underneath that video, mostly on Reddit, but also probably other places I haven't checked yet today. But basically, I got a lot of comments underneath those videos saying, wow, he's so hot, he's so cute, he's gorgeous, he's beautiful, he's so hot. And that made me feel really gross reading those comments where people are only paying attention to think he is attractive, and that's it. I mentioned it ages ago in a video, I don't remember which one, where someone said the media, when they first caught him, they mentioned, and I think a comment mentioned saying, oh, the media, they wanted pictures of Luigi Mangione, they wanted him hot, sexy, and that made me feel gross. I'm like, ew. Like, why do they want photos of that, of a murder suspect? There are a lot more photos of him out there where he is dressed really conservatively and respectfully compared to the photos the media used at that time. So I found this interesting, like, last night when all the photos started coming out for Luigi Mangione when he first appeared in court, when all the official photos came out. Someone mentioned the lucky long sleeve t-shirt Luigi mentioned in one of his letters, and I found that very interesting, and I very much think so. That's what he's wearing in that video, and the photos we see of him, I do think it might be that. I did mention that in a letter in the past, and I did find that very interesting. So in this case, I do really hope things go into Luigi Mangione's favor. I think I mentioned that in my last video too, but I really hope things do, go into Luigi Mangione's favor more so. Yes, it was a big win to get rid of the terrorist charges, and also when they got rid of majority of the evidence they have against Luigi Mangione, they got rid of that, and that is a massive win. But I do really hope in the next couple of months going forward, I really hope things go into Luigi Mangione's favor. And again, I will keep talking about Luigi Mangione's case. I will keep talking about what's happening with him and his case. I will only stop when Luigi Mangione tells me to stop, or his legal team. That's when I will stop talking about his case and making these videos. And I have been thinking about this lately. This case has slowly been turning more and more into something bigger than just Luigi Mangione himself. I want to say, hope you guys are okay after watching the trial. It has been a very anxious couple of months leading up to the trial. I think a lot of people have been really scared and anxious leading up to the 16th of September for Luigi Mangione's court appearance. But yeah, hope you guys are feeling okay after this week. Please take care of yourselves. Thank you for watching this week's video. I upload every week, sometimes 3 times a month, depends what I'm working on. I've been doing that a lot lately, uploading 3 times a month. These videos get really hard to make sometimes, or I'm burning out a little bit, or the mixture of both. Do apologize about that. But if you guys want to keep up to date with the channel, you can follow the channel social medias. That'll be in the description down below. And if you guys want to follow me personally, all of my social medias are down below as well. And I should keep mentioning this, but I'm bad at marketing. And if you guys have a case suggestion or a topic suggestion for that you want me to talk about, please put it in the description down below, or there's a little part on the website where you can leave a case suggestion or topic suggestion, and you can leave a lot more information and links and articles and all that there. And again, if you want me to talk about it, put it there. I don't mind. If you don't, that's okay. That's also okay. And yeah, thank you for watching this week's video. Please take care of yourselves this week. It's been a big couple of weeks. I've been anxious the entire month about this. Like, for 3 days I didn't do anything. I couldn't do anything. I was so anxious about this, and I know I shouldn't for a stranger. Anyway, thank you for watching this week's video. Bye. I'm so surprised the cat has not appeared in this entire video. She's very chatty, and I'm surprised she is not here. She's probably still asleep in the lounge room on our cat tree. She is very sweet. She's weird, but she's sweet. Anyway, bye.